take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas kneeling strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial. Yeah, yeah. Junkie on the freeway, white claw in a breeze. 2 hours there, 2 back, still typing with ease. LA lanes locked, but she don't slow down. Show up every time, yeah, she runs this town. Sitting in the traffic, but she locked in chat. If Sweet Pea goes live, yeah, she's right on that. From the 405 to wherever we at. Junkie pulling up like y'all good, I'm back. Different time zones, same front row seats. No matter where we are, we all meet in the free. We the Californians rolling deep all night. 4 corners, 1 crew, yeah, the vibes align. From the coast to the chat, yeah, we show up right. If you lost downstream, we gon' guide you like Californians. Yeah, we stay in the mix. 4 names, 1 flame, you can't remix this.
SD rolling with the sunset glow. West Coast haze where the good vibes flow. Little bit lifted, yeah, she stays serene. Ocean breeze mixed with the evergreen. Late to the stream, but she still gon' slide. Panel opens up, she already inside. Hold up, I'm here, yeah, she dropping bars. Calm, cool energy, no matter how far.
She got that FOMO, scrolling every stream. Little lost downstream, but she part of the team. New to the crew, but she locked in fast. Super chats flying, yeah, she built to last. Wait, where we at? But we got her back. Pointed to the right stream, never off track. Now she vibing with us, no need to roam. Anywhere we at, yes, Susie home.
Shamrock, yeah, Shamrock checking in from across the map. Different time zone, but she bridging the gap. Y'all good every time, yeah, she mean that. Heart so big you can't teach that. Algorithm running, she keep it alive. Dropping love in the chat, keep the whole thing thrive. Quiet power, steady hand in the dark. Every stream glowing got a Shamrock spark.
Yeah, junkie, 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 junkie,
Susie, Shamrock, Shamrock,
junkie, 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 junkie,
Susie, Shamrock,
Where
Shamrock.
we at? California, say the name twice. Show up every stream, yeah, we never think twice. From the traffic jams to the ocean tide, from the lost links to the worldwide ride. Californians, yeah, 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 we stay in the mix. Four names, one flame, can't remix this. Yeah, yeah. Oh, Californians, 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 yeah.
Good morning, good morning, good morning, everyone. Hello, hello, hello. What's going on? Whoop, whoop. Oh, man. Today is Wednesday. It is hump day. Good morning, good afternoon, good evening. Depending on where you at. I don't know. It just depends. Boy, oh boy. So we are on day 2. Yeah, day 2. I want to say like 3 because we did watch the jury selection, but whatever. So we are on day 3. And, I'm thinking to myself, well, I think that she's going to testify today. I think she'll start her testimony this afternoon. Remember, the case is supposed to go to the jury Friday. So at least that's what the judge said. That it was only supposed to be 4 days. And I think they can figure that out because the witnesses maybe is what I'm thinking. Hopefully we have some okay sound today. I don't know why these courtrooms don't have like mics and stuff in them, but they don't. Yeah, for some reason, when I was doing this yesterday, let me see. For some reason, yesterday when I was doing this, like my sound booster, it would boost it and then it would take it away. So I don't know what that was about. I have to figure that out. What could be doing that in that regards, because that was kind of awfully weird yesterday. But we did end up listening to it on Law and Crime. And if that happens again, one of those stations, either Law and Crime or Court TV, I can't remember which one we watched it on. But if that happens, we'll just go back there again and do it. But we shall see. we shall see how it goes. Let me go ahead and start with our good mornings. We got our judge on the bench, so let me go ahead and get started. Good morning, Jason. Hey, Lynn. Good morning, guys. Devil. How are you, Donna? Hey, good evening, Marilda. Look, I got it right. Yep, I'm getting better at this. Hey, Christian. Good morning. This should be morning time. Where she at? Yep. Hey, lady. Good morning. Yep, morning time. I'm getting it together. Martina, good evening. I'm be a pro at this. I'm gonna be known. Everybody is on this map. Hey, real happy. Good morning. Look, I'm gonna get great at this. Y'all gonna let me be great. Hey, Chevy. I'm gonna say good morning because you said good morning, so it must be morning time where you at. Hey, Eleanor. Good morning. Hey, Earl. I know it got to be morning time where you at. Yes. Hello, everybody. Anybody that is working, lurking. Lynn. I know she probably checked in and she probably working now. Good morning. Almost. Is it early afternoon? Oh God. I thought it was evening. Shoot. I was almost close. Oh man. God, I gotta get better. Yes, I do remember that y'all on the same time zone. Now that I got together because last night when Martina decided that, look, I am not gonna miss anything. I am gonna go to bed. I seen you was like, okay, I'm gonna go to bed too. Marilda, I see you yesterday. Like, okay, I think I'm gonna go to bed too. Oh, okay. So you are on. I don't know if that's like God's devil. That must be like what I'm on Pacific Standard Time. So it was like 6:29 a.m. here. Yeah, so when y'all be having these old East Coast trials, I'll be like, oh gosh, especially Florida, the capital of all the crimes. And I'm like, when they over there criming, we got to get up way, way early here on the West Coast, the Best Coast. That's Central. Yeah, it's early here. So like all the Cali little girls, y'all may see Susie come up in here. Susie don't even want to get up. It may be drunk. You drunk, you come in. SD, she come in all late because she can't get up in the morning. She be in the stream room all night on Discord. Okay, yeah. So y'all like in the Chicago, you and Devils, y'all like in the Chicago kind of area. So we gonna get into our day is kind of we are gonna cover this case first. Yes, I know. It's gonna end probably about I say maybe 2:30 if they do it that late. Yesterday it ended at 1:30 and we was all lost in the sauce because we didn't know what to do. So we ended up starting a case where the young man is accused of unaliving his grandmother and his younger brother with a hammer. We started that case yesterday. We did complete day 1 and 2, and so we will be in 3 today, just so everybody's aware. Yeah, so. Oh, I had to sneeze. Excuse me. At least I got to hit my mute button. Sometimes when it's coming, I be like, I can't do it. It won't let me. And then it go back, and then I'll be mad because I lost my sneeze. So we will do this case first, and then we'll go on that case, and we'll watch it kind of like on the expedited speed like we did yesterday. So without further ado, let me push play in here and see what we doing in this courtroom so far. I hope we don't go through all the objections that we did yesterday. I did do a clean version of it. I do need to put it up so we can kind of I don't know. Yesterday, I think the objections was, even though it was a lot when we was going through it live, when I went back and I edited the video to kind of put a no fluff version up for us. So if anybody needed to catch up, when I did that, I was like, well, maybe the objections is not so bad because maybe we might want to listen to them. But in the time that we was in court yesterday, y'all, after I cut down all the objections and all the breaks, For the most part, do you know we only have like 3 hours of testimony? And we said we was here all day. It was on stream for like maybe, I want to say about 6 hours. And we only have 3 hours of testimony. I was like, now what was they doing? Well, we only got 3 hours worth of testimony, actual testimony. And it may be even less than that, because I probably missed some of the objections that pull out, but I did try to get most of them for the most part. So if you see that no fluff version and you need to catch up on day one, that'll be out there. I'll put that out there later today. All right. Okay, let's see what we have here. I'm pulling myself down because, and I don't know why they don't have lapel mics in this courtroom. Oh man.
Records and reports, section of Rule 2:803, paragraph 8. Public records and reports. In addition to categories of government records made admissible by statute, records, reports, statements, or data compilations in any form prepared by public offices or agencies setting forth A, the activities of office or agency, or B, matters observed within the scope of the office or agency's duties as to which the source of the recorded information could testify, if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant. In business records, Ms. Jenkins, are you going under 6 in records of regularly conducted activity?
Let me check the numbers. Yes, Your Honor.
In reading that, so same section, Rule 2:803, paragraph 6. Records of a regularly conducted activity.
I don't hear the judge.
A record of acts, events, calculations.
So y'all don't hear the judge? Whoa. Well, wait a minute. Because I at least hear the judge. Yeah, that's the judge. I think what they're doing right now, they are talking about you can hear. Yeah, it is real. Let me see. Let's try going back where we went yesterday. I wanted to use them because it's just, let's see. She got that good old McDonald's coffee. My girl, we are friends now.
The Commonwealth Attorney is present with paralegal Ms. May. Good morning to you both.
Good morning, Your Honor.
We have defense counsel present, Mr. Rogers and Mr. T.
Good morning, Your Honor.
Good morning to you both. And we have the defendant, Ms. Ebony Parker, present at council table with the attorney. The jury has not been brought out. I believe we had an objection motion to take up and 2 matters with jurors that we needed to address. And anything else that you all would like to address before we bring out the jurors? Yes, Mr. James.
Your Honor, as to I think the court stated as the objection, I would ask that the efficient way to handle this is for it to be the Commonwealth's motion in limine to admit certain evidence. And there will be 3 things outside the presence of the jury that I'll seek to establish are admissible with 1 witness, Dr. Parrish, who is here. The 3 things that I'll seek to establish that are admissible are parts of the Newport News School District Handbook, parts of the Richneck Crisis Management Plan, and a video interview that Dr. Parrish did with the defendant. And so would court and counsel like to proceed on that matter first?
All right, and then Dr. Parrish, are we saying P as in Paul?
F-A-R-R-I-S-H. Yes, here.
That's right. Thank you, Mr. Jenkins. Okay, defense response.
Your Honor, of course, as the court has prevented me from making motions post our previous dates to do that, he's going to try to get these documents in. I'm going to obviously be objecting to them coming in. I really don't have a problem fleshing that out before we get before the jury.
Okay. And so I guess the defense responses are all motions in limine and things of that matter were to be handled in a pretrial fashion. And we had several dates prior to the scheduling of this trial to deal with those matters. Why are we dealing with it now?
Because the defense is objecting, and I must lay a foundation for 2 exceptions to be met. And those exceptions would be the public documents exception and the business records exception. And those are evidentiary issues that without an objection, I would never have known to file a motion in limine on. So they had to tell me they were objecting to those business records.
Okay, and to the business records, and the other exception was?
The 2 exceptions that apply to the documents, I think both exceptions apply, are the public documents exception and the business records exception. And of course, I'll provide more detail on that if the court wants me to go ahead with the motion as a motion in limine.
And to the 3 things you would like to introduce into evidence, do the 2 exceptions apply equally to all 3?
No. As to the video, it is a statement of a party opponent. It is an interview of the defendant by the witness who I will have here on the stand. So the business records and public documents exceptions, I wouldn't seek to apply to the video, but I would seek to apply to the policies of Richneck.
All right, thank you. All right, to Mr. Rogers. So what is your position if they're seeking to introduce it?
Your Honor, of course, I would have liked to have seen this motion in writing so that I could properly respond to each of those stated exceptions to the hearsay rule that they think that applies to this, these documents, so that I would be able to have statutes and case law to defend against having those things admitted. Regarding Mrs. Parrish's testimony, her testimony is going to be her testimony. I believe the Commonwealth is going to have a problem authenticating the video, so she can testify as to what she saw and observed. But regarding the playing of the video, we're going to be objecting on an authentication basis.
Okay, so let's break this down. 2, portions of the Newport News Public School Handbook, which Commonwealth is seeking to introduce. Let's not call this a motion of limine, but they're seeking to introduce. What's your position today?
Your Honor, my objection is going to be it's hearsay. It's going to be offered for the truth of the matter. So
okay, so let's deal with that. So the hearsay and Commonwealth has already responded that they believe it falls into the exception of public documents and business records. What's your position?
my position is does not. It's not a public record. It's a internal document that governs the policy of the Newport school system. And regarding a business record, if I could just look at
Yes, please. Okay, and let me pull up my rules book. And Ms. James, if you could point me to this section in the rule of the Supreme Court.
Your Honor, I have several citations that relate to the admissibility of this, and I'll have to lay a foundation with Dr. Parrish to meet the requirements, but I'll be happy to.
Okay, I'm still at the Newport News Public School Handbook. That's what you're referring to?
Yes, Your Honor.
Okay, but give me just the public documents here, say exception, statute and or rules number and business records.
Yes, Your Honor. Both the public documents and business records exceptions are codified under Virginia Supreme Court Rule 2803.
All right, and reading the public records and reports section of Rule 2:803, paragraph 8. Public records and reports. In addition to categories of government records made admissible by statute, records, reports, statements, or data compilations in any form prepared by public offices or agencies setting forth A, the activities of the office or agency, or B, matters observed within the scope of the office or agency's duties as to which the source of the recorded information could testify, if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant. And business records, Ms. Jenkins, are you going under 6 in records of irregularly conducted activity?
Let me check the numbers. Yes, Your Honor.
And reading that, so same section, Rule 2:803, paragraph 6. Records of a regularly conducted activity. A record of acts, events, calculations, or conditions if, paragraph A, the record was made at or near the time of the acts, events, calculations, or conditions by, or from information transmitted by someone with knowledge, paragraph B. The record was made and kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Paragraph C, making and keeping the record was a regular practice of that activity. Paragraph D, all these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 2:902, paragraph 6, or with a statute permitting certification. And paragraph E, neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Okay. All right, so again, we're back with parts of the Newport News School Handbook. Counsel seeking to introduce them, defense is objecting. Would the defense like to flesh out their objection?
Your Honor, I'll start with the records of regularly conducted activity. I would say that those handbooks are definitely not those. This contemplates records that are basically prepared from day to day, indicating the daily activities, business transactions of that business. That's not what we have here. We have basically a policies and procedures book. A says the record was made at or near the time of the acts against calculations of conditions. That's definitely not met. So the record was made and kept in the course of regularly conducted activities of the business. Your Honor, these are one-time documents, gets produced once a year, maybe once every couple of years. And making and keeping of the record was a regular practice of that activity. This isn't a record, this is a policy and procedure handbook, and it doesn't qualify as the records of a regularly conducted activity. So all of those conditions have to be met, which is capsulated in paragraph D.
Okay, and with respect to paragraph 8, public records and reports.
All right. Regarding the public records and reports, I would submit that policies and procedures handbook is not an exception based on a statute made admissible by statute, and it's not a record or report or a statement or data compilation. So I would submit that it doesn't qualify under that paragraph either.
Okay. Anything further from the Commonwealth?
Yes, Your Honor.
And again, we're going one by one.
Okay, so with respect to the manual being a business record, I'll start with that one. I'll ask the court to rely on the case of Carmody v. F.W. Woolworth. Carmody is C-A-R-M-O-D-Y, v. F.W. Woolworth, W-O-O-L-W-O-R-T-H company. It is 234 VA 198. In that case, an employer's employee manual was admitted under the business records exception to prove what a particular employee's duties were. And the court held that it was properly admitted under the business records exception. And so that case establishes a business records exception, and the Supreme Court has said that an employee manual, if kept in the regular course of that business, is admissible under that exception. I'll turn to the exception for public records as well. Actually, Judge, as to public records, give me just one moment.
Yes, sir.
As to public records with the school handbook, the policy handbook, it is a report prepared by a public official, that being the school board, pursuant to the nature of their office. So it requires that they, by nature of their office, produce policies that relate to the schools under their direction. And given that, it's admissible under Williams v. Commonwealth, that's 213 VA 45, 1972, among 3 or 4 other cases about public documents. I will have a different argument on that related to the crisis management plan.
Yes, sir. All right, anything further as to the Newport Public School Handbook?
Right, could I have just a moment to look at that Williams v. Commonwealth?
Yes, sir.
Did you say Williams Commonwealth or Newport? Williams versus that Newport. Not criminal case. Cypress 213, VA35.
I cited a couple of different cases. Are you the last? Williams v. Commonwealth is 213 VA 45.
45. I'm not sure if the court has had a chance to pull up that case.
Yes, sir.
Okay. So it really does not support the Commonwealth's position. It is a case where the Commonwealth is attempting to get in information from the Central Criminal Records Exchange, and it's the rule that it's referring to. It says it is generally recognized. It is a generally recognized rule that records and reports are prepared by public officials pursuant to a duty imposed by statute or required by the nature of offices or admissible as proof of the facts therein. And it goes on to say, but the mere fact that a record or report qualifies as a public document does not automatically overcome state protection of record.
Talk too fast for the man report.
I'm sorry. Unless the document relates facts or events within the personal knowledge and observation of the recording official to which he can testify should be called at trial. That's not what we have here. So that does not support the Commonwealth's position.
Thank you. So regarding the Newport School handbook.
I'm
Oh,
sorry.
yes, sir.
Mr. T is reminding me, the very first case, it's a civil case and it's not a criminal case, so it doesn't apply.
Thank you. So the hearsay exception of public records and reports does apply to the Newport News Public School handbook. And we can distinguish the cases as Williams refers to the CCRU, which is a criminal record database and history, and here, which is a different public record. And again, there are exceptions for public records compiled by law enforcement. And then again, defense started to distinguish the civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the Newport News Public School handbook comes in. Now, the Richneck Crisis Management book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Farish is here and knows more than I do. But the crisis management plan is a document that the school board is directed to require individual schools to create and to update annually. This comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building, not just violence, but just any sort of crisis. A fire, a natural disaster is covered, but many things are covered.
Are there scenarios that are factually close to the facts reported, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions both on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I'm seeking to admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object to that either.
Okay, and then you said you had additional argument on why this is admissible. If you'd like to go into that now so that they can get their cases together and be ready to respond.
Yes, Your Honor. For the crisis management plan, the strongest argument for its admissibility is the public documents exception. And that's because they are required to do it by statute. And that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records, who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the public documents exception.
Thank you, sir. Yes, Ms. D.
Your Honor, regarding the handbook and this, the manual that was just referenced by the Commonwealth, the issue with these documents coming in is that it's going to be very dangerous and can confuse the jury. This is a criminal case. The handbook and the manual cannot set the criminal standard here. They're containing, as the Commonwealth has stated, there's a plan in place for what is supposed to happen in certain situations. I believe that the jury may confuse that with the criminal standard. This is a criminal case, it's not a civil case. The criminal case, the criminal standard is much higher than any, and it's not governed by the Newport Public Schools handbooks or manuals. So while they may be relevant to the standard of care followed by Newport, they cannot be used in the analysis of criminal culpability. Additionally, the manual and the handbook presuppose supports that were not present at the Richneck Elementary School that day. In the manuals, it contemplates that there is a school resource officer in the building. That is not present here. So there are supports in those manuals and handbooks that are assumed that are not present in this case. So we object to the admission of both.
May I respond briefly, Judge?
Yes, sir.
The arguments of counsel just now are fair arguments for him to make as to the weight of this evidence, but those arguments don't go to admissibility. The admissibility is defined by the rule and the case law, and I understand counsel's position that there's little relevance is what it sounds like, but there's certainly enough relevance that it should be admitted, and that argument that we just heard could be made to the jury.
So, in respect to the Richneck Crisis Management Manual, the court does find that it qualifies under the hearsay exception of public records and reports. Now, I will say there, because it is required by statute, doesn't make it admissible by statute. but it meets all other requirements of the public records and reports. And just for parties' edification, I do not find that these are qualified, neither the public school handbook or crisis management manual under the records of a regularly conducted activity, as it has to be established that it was made at or near the time of the act or events or calculations. Annual manuals are different from a receipt, a purchase receipt. That's time you can't say I bought this item then, which is a business record made at or near the time of events. That had not been established, so it would not come under that exception, but it does come under the other exception. All right, the third matter is the interview with Dr. Farish, a video interview. Now, I don't know what this is. I don't know what it's purporting to put in evidence. I don't know when it was recorded. So if you could proffer to me some of that, and then we'll get into why you believe it's admissible and why they're objecting.
Yes, Your Honor. The video was recorded as part of an internal school investigation by Newport News Public Schools Human Resources. The interview was conducted over Zoom. On the recording of the Zoom, you can see that Dr. Nina Farish from Newport News Public Schools, the HR director, is asking questions of the defendant, Dr. Ebony Parker. The video, I don't remember its total length, but in the video, the HR director is asking several open-ended questions about the incident at Richneck Elementary, and Dr. Parker is answering those questions about the incident.
Okay, and do we know the date or how was that taken in relation to the incident, to January 6th? I believe it was 2023.
Your Honor, if I could have just a moment to look that up, I think I can. Fine. Your Honor,
Yes, sir.
if I may, what I can tell the court myself is that the the HR director was assigned to do this report and began her investigation on January 9 of 2023. As to what day she interviewed the defendant, I don't know, but she is here, and I'll be happy to have her testify to that fact.
Okay, if we need to get to that point. And you believe this is admissible, you said, under admission by a party opponent?
Yes, exactly as any criminal defendant's statements or confessions would be admissible. It's both a party opponent, and a statement against interest.
Okay, all right, and let me read those into the record. So again, under Rule 2:803, paragraph 0, admission by party opponent. A statement offered against a party that is A, the party's own statement in either an individual or representative capacity, or B, a statement of which the party has manifested adoption or belief in its truth, or C, A statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or employee made during the term of the agency or employment concerning a matter within the scope of such agency or employment, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. And give me the second one, Mr. Jenkins. What paragraph am I looking for?
Judge, I called it a statement against interest, but I think that that really is encapsulated in the Virginia rules as an admission.
Okay, yes, the other one has to deal with property only.
Yes.
Okay, all right. Oh, okay, all right, defense.
Your Honor, regarding the statements that my client has made, there's really no reason to object to any of her statements. Again, the problem that we're having is the video, indicating the video. If Ms. Farish testifies, that's the statement that my client made. Can't object to that coming in. But as far as playing the video without proper authentication, then we
Okay, understood. And all of these are still subject to all of the other rules of evidence, especially regarding authentication. But we're just trying to get those out of the way. Okay, so then we'll interview with Dr. Farish. Again, assuming it meets other admissibility requirements by law, it comes in. All right, anything else we need to take up other than juror issues?
No.
Your Honor, Mr. Teague has also advised me that we definitely have concerns regarding the actual interview, the coercive nature of the interview, that setting in whether my client felt like she had a right to not give those statements. Rather, we definitely believe that as far as the video is concerned, playing that before the jury would have a profound prejudicial impact on the jury, and we would ask that even though it's relevant, that the court exclude it based on the prejudicial nature of the statement.
Okay, and did you receive this in scope?
I did.
Okay, why didn't we deal with that in the pre-trial motion?
I'll submit it.
Okay, you made your position for the record, but it is going to be allowed in. Okay, so we have two juror issues. I'm sorry, go ahead, Mr. Rogers.
You say it's going to be, her statement's going to be allowed in, but at this point,
Again, it still has to meet other rules of admissibility. But in terms of you saying that she didn't have counsel, she didn't know that she didn't have to participate, if those things could have been done prior to trial and were ordered to be done prior to trial, and they were not. So I'm not considering anything else regarding that. Now, we had one juror state she had a question, and we had one juror indicate he would like some clarity regarding objections to stricken evidence. My position was to have the juror who had the question write it down the juror number, and we read it out here on the record, and then I'll ask attorneys how they want us to respond to it. Do you all prefer to proceed in a different format?
That's fine for the Commonwealth.
that's fine.
Okay, and again, they are not to be deliberating. So do you want to have just that one juror brought out here and write the question down so that it's not in front of the other jurors, or do you want the question asked in front of all of the jurors, or just pass us a sheet of paper?
I'll defer to the defense on how they want that.
Your Honor, we have no problem with her just writing it down, not being viewed by the other jury members, and then read by Your Honor.
Okay, so Sheriff's object, and I don't know her juror number, but it was the young lady who sat in the first row far left. If we could have her write down, I'm asking her to give me a sheet of paper with her juror number and to write down her question and just hold it out, so that the other jurors can't see it, and we'll bring it out here and read it on the record. Thank you very much. While that is happening, we did receive several media requests for copies of Commonwealth One, the video being played, and it has not been sealed to this point. The parties have a position to that. So that would have been the video of Ms. Kovac having JT in a bear hug, which was not played, but I just want the parties to know the media is asking for it. As of now, it's open and not sealed.
Judge, I would ask to seal it because a minor is depicted in the video.
Okay, that's it. Action on
That's my
the position.
Your Honor, I support the Commonwealth's position.
Okay, so Commonwealth One will be marked sealed. Thank you. You need anything else, Madam Clerk? Can you sign that?
No, ma'am, but I will let downstairs know.
Okay. Oh, did he bring up the question?
He did, it did not have a juror number on it.
Thank you. Thank you. All right, juror number 38. What is written on this paper reads as follows. What are the 8 felony counts? The time from recess to shooting? Did VP make 911 call? How would parties like the court to respond? And I'm happy to pass. Sheriff, you can pass that down. They can each see the sheet.
I believe that the court should instruct the jury members are going to have to rely on the memory of what they perceived evidence was.
I think that's true, but I think also that they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence the court admits during the course of the trial.
Okay, and again, the court concurs, so that juror will be instructed to rely on their recollection, but wait till the conclusion of all evidence. Therefore, there will be more evidence presented, and to not start deliberation until the case is given to them. So, yes, Mr.
But on that point, Judge, I feel like it is incumbent on us to voir dire the jury members, both based on her question and the gentleman's question as well.
Yes, the gentleman, absolutely, but you want to voir dire her as well regarding if she spoke about this with other jurors?
Yes, only for that limited purpose, whether she's spoken about it with other jurors. I certainly don't want to ask any questions about these 3 things she mentioned.
Okay. Defense position, if any.
I agree that she definitely needs to be brought here.
Okay, and so that we have a game plan when she comes out here, we're just going to keep it to has she, are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry without us.
I just want to, okay.
And I would ask that the court inquire, has she observed any other jury members discussing anything pertinent to the trial?
Okay, those will be the three questions. Okay, thank you. Okay, so Sheriff, if you can bring out just juror number 38, please. I'm also coming out again. I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question. There's no super. Good morning, yes, you have a seat in the jury box. Thank you. Good morning to you.
Good morning.
Okay. And I do want to remind you, of course, you're not being recorded. You're not on video. You can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation. And that would be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. So that's why I'm not answering your specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we had 1 question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions are on, like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given, because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they're not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment. Let me see if the attorneys have any follow-up.
I don't.
I think
Okay. All right. Thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is? Oh. Okay, yes, so bring him out. I don't know his number. Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right, and again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in the witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollections as best as you can. Just come up with a different response.
No, not on that issue, Judge.
does the defense wish a different response? And I do understand we're going to ask some other questions about the weed part. But Mr. Rogers, can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying,
Okay.
as it did before.
What, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
Okay. Ms. Steve?
Yes, Your Honor, I think my clarification that not only that they rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point. Well, what if I don't remember what was struck or not, and I got confused in the sustained, overruled? You can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles in the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to verify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word we several times. Why do you use the word we, and are you discussing that? Have other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none had an answer.
Okay, and other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No, ma'am.
Okay, and the reason why I ask is because they're not to discuss the case, which is deliberate until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case.
Okay.
Okay, all right, I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have any questions.
Okay, Mr. Jacobs.
I don't have any questions.
Okay, thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38.
No, 33. Thank you. 33. Juror number 33. I'm sorry. Thank you. You retire to the room. Okay, anything that someone would like to address before we bring the jury up?
Your Honor, can I just step out for a quick minute?
Yes, sir. I'll give you that. Keep your seats.
They can start with there are the jury. You gotta just have juror number 33. He is the one that well, we don't know what to consider. Because I don't know, right? It's the same, like, we had a lot of this going on yesterday. To the point, I don't even know what place was not to all the back and forth right in front of the court. This is not a good look, right? Because the jury is on it. So, we're number 2 really hand close. Is it better now? Sorry. I was just saying that I can definitely understand what her because you have all those objections, all those things going on yesterday. The jury was right here on the record, so they're not in the bag. They had everything adjusted and everything. It's still muffled. I'm still on the time. I guess it's gonna make me pause it. Sorry, guys. Yeah, so I was just saying with juror number 33, I definitely understand what he's talking about because we had all those objections, all those things sustained, all that stuff, right? And with that being said, they did it all in front of the jury. So the jury really don't know exactly what they supposed to keep in, what they supposed to let out. They don't know any of that stuff. So I think that's going to be a big issue because they did all these speaking objections. So I think number 33 is right. So when she talk about you got to go based off your recollection, but what if you recall something that you're not supposed to recall because it was sustained? Or you don't take something in because it was overruled. And so he asking about his notes. Now, juror number 38, that the young lady that came out, the juror before him, I put up there where her questions were. Now, she asking about the 8 felony counts. She want to know about that. She want to know the time of recess to the pew-pewing. Now, I want to know that too. Remember, we were trying to go out a timeline. So that just let you know that they have not clearly made this clear to the jury on a timeline of events. Pretty Brown Girl, I know she sent it in Discord yesterday, the best timeline that she can find. So that let you know that the jury is still like, what, okay, tell us what time this happened so we can kind of base off like who was doing what at what time. And they're not making that clear. And then the last question was, did DP make the 911 call? Now, I don't know. I don't know who DP is. Yeah, Kent, you might be behind. Yeah, I muted the feed. I'd be glad when I can figure out and learn how to talk over the feed. I be trying in different ways. Oh, Dr. Parker. Thank you, CCGTV. I couldn't figure out. I'm like, I don't know who DP is when they used initials, because I thought they were using initials for the kids, but yeah. Martina, none of them said they discussed the case with each other. I don't know, but you know, to think about these things that are going through I mean, these are questions that we still have. So I guess in a way, it gives the attorney some type of idea of what they're not doing wrong. I mean, what they're doing wrong right now and what the jury still needs clarification on. Yeah, one day I'll be able to talk over the stream. Like they wasn't even saying anything, so I thought I would be able to talk over it for real. But it keeps me muffled. I tried to put my headphones in. I'm gonna learn how to do this one day. One day I'll be there. I don't know why they did all that talking in front of the jury yesterday. It was ridiculous. Like they didn't send the jury. They sent the jury out one time. Okay, you say, well, hopefully it sounds better on your end, Kent. Yeah, I caught myself muting the little thing for us, but yeah, let's go back in here and let's see. Maybe she matching her clerk because her clerk's shirt matches her earrings. Maybe that's what we got going on today.
Number 33. Anything in addition to this or any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they discussed the issue or discussed the case. Several times he used the word we, indicating that there had been deliberating before discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number,
Was that the young lady?
Yeah.
38, she's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the Commonwealth with knowing what is important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for this trial.
Okay.
Can I just move?
Yes, sir.
Judge, with respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have two alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Jurors 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about juror 38's questions, juror 38 could be released as an alternate and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and follow the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. And let me add to this. The sheriff has indicated juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad. So Let's bring him back out again and see what's in the notepad. Well, hold on, Chair. Yes, Mr. T.
Just for the record, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He said that they didn't have.
Oh, they said they did. Yeah, you're right. They didn't know.
Right.
The
So there's, to me, that indicates.
So let's follow up on that. Okay, bring out juror number 33 again, please. Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, we, two questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, he said he could not answer it, which was sent to you.
And you posed question to who? Oh, okay, gotcha, the chair, okay?
Yes.
And he said he could not answer
Could
it.
not answer that as a question for the judge. And he stepped out. He said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses, but generally it was just a. I apologize, I did not try to log it in my memory. I don't remember any particular responses as much as that might be good to clarify. It'd be good to know. The conversation moved on, I believe, to traffic cameras. So, I believe that was the extent of the conversation. I'm sorry, I can't be more.
So your memory is fine, and, so did anybody, were there responses, or did they reach you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was a general assent that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it
I
a
would
verbal?
say verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay, and do you know how many would have shared that, if you can approximate?
Maybe 3 or 4 people at most.
Okay, and those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of passing mentioned that the conversation moved on to traffic cameras.
Yes.
Is that right? Was it like, could you describe the nature of what that conversation was?
Trying to remember, because it was going between considering my question, sipping my coffee, and generally paying attention to traffic, so I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, so we're finding other topics of conversation. People were discussing times that have been clocked by traffic cameras.
Okay, so
That sort of thing.
sure. So it wasn't in relation to is there traffic camera evidence in going to be shown in this case? Or, okay.
No.
Oh, thank you. I don't have anything further.
Okay, Mr. Rogers and Mr. T.
Yeah,
Okay, no additional question. Okay, and then juror number 33, it was mentioned to me that you had an extra notebook. Are you reporting any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to take other notes, the notebook was placed down on my feet and has not moved from that position.
Okay, wonderful. Thank you. And
You're
so
welcome.
again, let me, because I changed the topic, I'm going to turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. And again, you were not in trouble, but we just have to make sure everything is perfect.
I certainly report.
That you can retire back to the jury room. Thank you very much.
Thank you, ma'am. Thank you, Vincent.
Okay, anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same. No,
My position remains the same, and just want to note that the juror seems to not remember, not remember exact conversations that went on regarding the issue.
So again, I'm going to retire the deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that, and the responses, I think will be harmless, but let me research it and consider it in detail. And I'll be back in, let me see, it's 9:54. Oh, let's see, try to check in at 10:15. And then, Madam Chair, will make sure jurors have, extra snacks and whatever they need, because they've been in that room a good hour and 15 minutes left. Okay, I will be in recess. Thank you.
all right.
While that is happening, we did receive several media requests for copies of Commonwealth One, the video being played, and it has not been sealed to this point. The parties have a position to that. So that would have been the video of Ms. Kovac having JT in a bear hug. which was not played, but I just want the parties to know the media is asking for it. As of now, it's open and not sealed.
Judge, I would ask to seal it because a minor is depicted in the video.
Okay, that's it. I just want to know your position.
Your Honor, I support the Commonwealth's position.
Okay, so Commonwealth one will be marked sealed. Thank you. You need anything else, Madam Clerk? Can you sign that?
No, ma'am, but I will let downstairs know.
Okay. Oh, did he bring up a question?
He did, it did not have a juror number on it.
Thank you. Thank you. All right, juror number 38. What is written on this paper reads as follows. What are the 8 felony counts? The time from recess to shooting? Did VP make 911 call? How would parties like the court to respond? And I'm happy to pass. Sheriff, you can pass that down. They can each speak the shooter.
I believe that the court should instruct the jury members are going to have to rely on the memory of what they perceived evidence was.
I think that's true, but I think also that they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence the court admits during the course of the trial.
Okay, and again, the court concurs, so that juror would be instructed to rely on their recollection, but wait till the conclusion of all evidence. Therefore, there will be more evidence presented, and to not start deliberation until the case is given to them. So, yes, Mr.
But on that point, Judge, I feel like it is incumbent on us to voir dire the jury members, both based on her question and the gentleman's question as well.
Yes, the gentleman, absolutely. But you want to voir dire her as well regarding if she spoke about this with other jurors?
Yes, only for that limited purpose, whether she's spoken about it with other jurors. I certainly don't want to ask any questions about these 3 things she mentioned.
Okay. Defense position, if any.
I agree that she definitely needs to be brought here.
Okay, and so that we have a game plan for when she comes out here, we're just going to keep it to has she, are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry without us.
I just want to be, okay.
And I would ask that the court inquire, has she observed any other jury members discussing anything pertinent to the trial?
Okay, those will be the 3 questions. Okay, thank you. Okay, so Sheriff, if you can bring out just juror number 38, please. And also come out, again, I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question. There's no secret. Good morning, yes, you have a seat in the jury box. Thank you. Good morning to you.
Good morning.
Okay. And want to remind you, of course, you're not being recorded. You're not on video. You can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation, and that will be at the conclusion of all of the evidence. And I can't, you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. So that's why I'm not answering the specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now we had 1 question for you, or maybe 2 questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions alone. Like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any of the jurors discussing the case? Because they're not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment, let me see if the attorneys have any follow-up.
I don't.
I think of it.
Okay, all right. Thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is? Oh. Okay, yes, so bring him out. I don't know his number. Oh, good morning, sir. You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right, and again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in the witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollection as best as you can. Just come up with a different response.
No, not on that issue, Judge.
Does the defense wish a different response? And I do understand we're going to ask some other questions about the weed part. But Mr. Rogers, just can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying.
Okay.
As it did before.
What, giving the same response or offering clarity? Giving the response that he has to reply, the jurors have to rely on their independent recollection.
That satisfies the defense.
Okay. Ms. Steve?
Yes, Your Honor, I think my clarification that not only do they have to rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider it.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point, but what if I don't remember what was struck or not, and I got confused in the sustained, overruled, you can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles and the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to verify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. Now, you use the word we several times. Why do you use the word we, and are you discussing that? Have other jurors expressed the same confusion?
The other jurors did not express that confusion to me. I posed that question to the other jurors and none had an answer.
Okay, and other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No.
Okay, and the reason why I ask is because they're not to discuss the case, which is deliberate, until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case.
Okay.
Okay, all right, I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
All right.
We don't have any questions.
Okay, Mr. Jacobs.
I don't have any questions.
Okay, thank you, juror number 38. You can retire to the room. We have one more thing to take up, and then we'll start the case.
Quick correction, Judge.
You have a question?
No, quick correction. Just now, we referred to him, the court referred to him as 38. He's
No, 33. Thank you. 33. You're number 33. I'm sorry. Thank you. You retire to the room, please. Okay, anything that someone would like to address before we bring the jury up?
Your Honor, can I just step out for a quick minute? I'll be up.
Yes, sir. I'll give you that. Keep your seats. Number 33. Anything in addition to his report? Any comment on his responses?
Yeah, sure. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they discussed the issue or discussed the case. Several times he used the word we, indicating that there had been deliberating before a discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number Kim,
Was that the young lady?
Yeah.
38, she's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the Commonwealth with knowing what is important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examination of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for mistrial.
Okay.
Can I just move?
Yes, sir.
Judge, with respect to the issue with number 33, sort of announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started to start them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. You wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have two alternates.
They are back in the court, so I'm pausing right here. So I can bring this up to speed in the courtroom.
All parties are present in the courtroom, minus the jury, and there was a mistrial motion made. The court had an opportunity to consider it and research it. Anything else parties want to say before the court announces a ruling?
Nothing from the Commonwealth.
Your Honor, just for purposes of the record, I just want to clarify the motion as it relates to juror number 38. She submitted a series of 3 questions, which again, we're arguing that helped, I believe, would aid the Commonwealth in planning out the rest of their case directly in response to her questions.
Thank you. And in response to the mistrial motion made regarding juror number 38's question, the court will deny that on the legal principle that the jurors in this matter are actually the triers of fact. And under law, they can ask questions of the witnesses. Now, of course, our courts aren't set up to do that. We don't encourage it. We don't normally do that. But it is not prohibited. And all the evidence has not been presented in this case. And both sides can adjust accordingly based on those questions. But again, jurors are the trier of fact in this case, and they do have the ability to ask questions and can actually question witnesses. So that's the legal principle there. Regarding the motion to mistrial based upon juror number 33, asking questions of other jurors, which means discussions prior to the case being submitted to them for deliberation. The defense has moved for a mistrial. The Commonwealth has joined. The court is going to deny the motion for a mistrial, and the case will proceed. The court's rationale is as follows. The determination of whether a mistrial is warranted depends on whether the juror misconduct probably resulted in prejudice to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct was prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure of the jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct, and that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court, a legal decision, and a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holby, and the Day versus Commonwealth, in addition to the statute cited. All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the juror.
I think so, and to hear her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out and then having to exclude them again, so we could lay the foundation and authenticate the video, I think it's for judicial economy, we should just go ahead and bring her out, follow her, authenticate the video, and if the court believes that the authentication is proper, go ahead and present that evidence to the jury. Ron, I do have another concern, and that is at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they may be discussing the case, may have heard about the evidence that has been presented in the case, and may be discussing that. And so I'm concerned that the court's ruling on sequestering nuclear witnesses may have been violated and is being violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what they're speaking about.
All right, without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And Commonwealth's witness that we're going to pre-clear the testimony for evidence.
Yes, Your Honor. Nina Farish, Dr. Farish.
Okay, bring out Nina Farish, please.
Raise your hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay. Watch your step, there's a stair, and the chair and microphone are adjustable. And Ms. Farish, we're going to take some of your testimony outside of the court for the jury. We'll look at any objections and evidentiary issues. And upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. Okay. If the attorneys have any questions, we'll start with the comment. Yes, Ms. Ross?
Before the video, I would like to coordinate her during the video prior to her actually speaking.
Okay, and I don't know what order Mr. Jenkins was going into. Do you want to start with the questions, Mr. Rogers?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay, yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport Public Schools.
Were you employed in that same capacity in January of 2023?
Yes.
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Richneck Elementary School that occurred on January 6, 2023?
Yes.
As part of your investigation, did you have occasion to interview numerous people?
Yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom.
Okay.
Recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes.
And what was prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
Assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes.
Could you please just point her out for the judge?
Okay.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes.
All right. And was that interview conducted in person on Zoom or some other way?
Via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes.
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think, does.
Good morning, ma'am. How are you? Great. So regarding any video that was produced, Did you keep, or were you the sole custodian of that Zoom video?
Yes,
Okay, and where was that video maintained?
on my computer,
Okay. Did anybody else have access to your computer, or was it just you?
just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins, the Commonwealth?
No, I'm trying to remember the name of the law firm because as I recall,
so the civil attorneys?
Mr. Jenkins was not the original attorneys.
The civil attorneys?
Correct.
Okay. So have you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes.
When did you review that video?
I reviewed the copy that I still have and I reviewed it to refresh my memory.
Okay, I want to make sure that you understand my question.
Okay.
The copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video, and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into the possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay, and again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. Oh, I'll tell you what, I'm going to let Mr. Steve step in.
Good morning, Ms. Ferris. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recording.
Okay, so you did not actually record it with your own device or anything like that?
No.
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
Repeat that question.
You said, I believe your testimony is that Zoom recorded it. You pressed record on the Zoom platform.
Correct.
And Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording
Mm-hmm.
and it can play for me.
Okay. Thank you.
Okay, and one moment, Dr. Ferris, any further questions before we?
Just arguments at this point.
Okay, your arguments are towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that the Commonwealth has. She hasn't viewed it. She's testified that she cannot verify that the whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could have been run through artificial intelligence and altered. she testified that she can't, she's not in a position to be able to verify that.
Do I have permission to play the video?
Yes. And Ms. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having to examine it ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
If you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
Your
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Ms. Rogers?
Your Honor, Commonwealth has already admitted that the video has been altered. So with that admission, she can't vindicate it. There's been, Commonwealth would say minor alterations. But Your Honor, I'm not comfortable with just presenting clips. She needs to authenticate the whole video, and if part of it comes in, I think all of it's coming.
Okay. Do you have any authority for that position, Mr. Rogers? Because I'm unaware of the authority that if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that that makes it inadmissible?
No, I don't have any authority regarding the muting or the name of a minor, but I'll just cite BS versus Commonwealth. And I've got a copy of it before.
Okay. And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. It doesn't address that.
Okay, but the other thing you're saying, if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I just, I'm going to object to just a part of it because of the importance of context. If some of it comes in, I just think that jury's entitled to it.
And Commonwealth is very not objecting to that. So what I'm asking you is, how do you want that? And well, let me back. Mr. Jenkins, how long is the entire interview?
Oh, I will have to look at that.
That's when I asked Mr. Rogers, are you asking him to play the entire interview?
Yes, ma'am, essentially.
Okay, that's what I want to know. How long is the interview?
So,
The whole video is 28 minutes and 58 seconds, I show. Let's see if that's right.
Okay, that's fine. Okay, all right. So we'll play the whole video for the jury should it be the other notification changes. Anything else, Mr. Rogers?
That's it.
Okay, so Mr. Jenkins, what are you prepared to play now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way. But.
Mr. Rogers?
So I'm gonna ask that she be shown the entire video, but then when it comes down to the presentation of the evidence, then I would suggest that the Commonwealth can show clips at that point. But I want the jury to have the whole video. I want the whole video reading the evidence.
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that it has been properly vindicated.
Okay, all right, so we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Farrah, she's going to show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know.
Your Honor.
Yes, Mr. Dixon.
Just before we start, I would note that Mr. Commonwealth has indicated that all of the 3 clips have been melded into one file. So they've been joined together, which I think obviously jump would mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're one melded video that's combined into one file. I don't think that would be fair to Dr. Parker, because it would leave out. I'm assuming that he's jumping. Had they not have seen this video, the splice one, it jumps. He's saying that he's joined 3 clips together into one file that plays and changes.
Okay, well, let me hear from Mr. Jenkins.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts. But.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, sir. I think that that's an alteration that goes beyond people's names and clicking, making slices that are obvious to the jury. I just don't think that should be played to the jury.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of the video.
No, we don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible.
I'm not aware of it. Okay, and Mr. Rogers, what case law has you named up?
Your Honor, this is, Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin, but the rule begins at, you'll see, designated paragraph 1819. That's probably like 6 pages back. It says, beginning of that paragraph, it says, photograph or video, which is verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just going to go on down. It says that the silent witness or a witness that speaks for itself, video, photographic evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing. Obviously, this splice video is not something that she's going to be able to verify the accuracy. And so, going down to paragraph 2223, the second says, focusing the authentication clause on one street moment with two more to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, well, witness to affirm that the video is accurately so in terms of video, it's not necessarily to testify every moment, rather than seeking for witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has submitted this video in its form as it's been offered. Obviously, the Commonwealth is going to be presenting a video that points more to Dr. Parker's guilt than innocence. So, in this form, it's highly prejudicial to Dr. Parker, and we don't believe that just such that should be presented as Commonwealth has a certain prepared. Obviously, Ms. Ferris had not seen the clips in the form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I know the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the three different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video was admitted, presenting the complete unredacted copy to the jury. Is that
still a defense request, and Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. All right. Yes, sir. You may proceed.
Thank you, Judge.
Okay. So Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred in Richneck on Friday. Yes. Okay. So it's
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Okay. Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview. So
Mr. Rogers?
She's only seen my client's face. She certified that I just want to ask if, for purposes of identification, there's no way she can verify because what's on this 16-minute clip is accurate. She has to see it.
Ms. Jenkins, if you just jump to 2 other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can. Oh,
sorry. I'm seeing at the bottom of the screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on video or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was recorded.
Oh, understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those were the only 2.
okay. So help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
Okay, I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay. All right. So just to be clear.
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
All right. Judge, with that, I think we've laid a sufficient foundation for authentication purposes in this video.
Anything additional from the defense?
No, just to try to stress the whole point of authentication is to verify the accuracy. Your Honor, it's going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the possession of those other attorneys or any IT professionals, any other person between the chain from affairs, the other attorneys in the Commonwealth. Just showing her those very few seconds that she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that video.
Yes. Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related to that? Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter. Yes, ma'am. All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. So it is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
Chair, if you kindly bring the jury out, and do ask all parties to stand while the jury comes out. If you're able,
Your Honor, I'm going to step out and let them.
Okay, well, step out, Mr. Rush, yes, sir. We'll wait till you come back.
Thank
I'm sorry, everybody, get your knees in your back stretch. Yeah, it's a good stretch break, let's stretch. Here we go. Are you all good? Yes, ma'am. Okay. Okay, all attorneys are back in place, and we will bring the jury out. Thank you, Sheriff. Again, let's practice, let's all stand. Let's stretch.
Jurors in the box, please.
Thank you so much. Everyone to take their seats, please. Do you mind? That's the head count. 14 jurors are in the box. Happy Wednesday to everyone. Thank you for the time this morning. I know you've been there for about 2 hours. We were working on some motions. Hopefully keep a swift pace through the day. As usual, we'll try to break around 1. And try to include around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we have that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction. Again, amongst yourselves, please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. So you can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start the direct examination. Mr. Jenkins.
Thank you, Your Honor.
Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farish, Human Resources Director for Newport Public Schools.
And Dr. Parrish, how long have you been in that role?
For 4 going on 5 years.
And so were you in that role on January 6, 2023 and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Richneck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Richneck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, defense has objected, and of course allowed that the video will be played. I don't think it requires their name, but do either of the attorneys want the courtroom to be dimmed?
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer the questions honestly. I also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack. So, Ms. Kolak, will I use names?
Yes, ma'am, please.
Okay, so Ms. Kolak was the one who informed me of this. And she said that she had already asked the student, is there something in your backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, putting off tickets and such. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she said, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So I I don't know if she went outside or not, but there was a comment that said, well, we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between them, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Do we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack. And again, I'm still using we, but it was Miss Kovac. I said, his backpack was checked. We didn't see anything. And he says, oh, okay. Did you check the person? And I said, oh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and then she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those are the only two.
Okay. So help me understand, what is your understanding of what should have taken place from the first notification that you received about the student from Ms. Kovac possibly having a weapon?
What we did in previous times before, we had 2 other students who also reported to have a weapon. And we, asked the student, if you have something that say, no, we do have someone else come in with us to look in their backpack. But we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day, and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, and correct me if I'm wrong, you've brought the student into your office, and you, along with who else?
So the first time it was Mr. Rawls, and then the second time It was an incident of a parent had already called the police because the report was given to her from her son. So she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mrs. Zwerner on that Friday come to you and express concern about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Warner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay. And then she left. So I told Ms. Kovac, because they were going to go down as the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say that.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
No, so it has been on my schedule since the beginning of the year. His acting out was he's extremely defiant, and he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place. So somebody was getting the bus. He was going to Ms. McBurnett's room to do a social story. He was then transitioned to Ms. Kovac for a 15-20-minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office. And he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, no, the damage that it is to the teacher's phone. We'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm going to call his mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but, I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Zwerner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do, Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was like pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that that was what was reported Wednesday, that's where I think that came from.
Okay. Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. When prior to Friday, had anyone, Ms. Zwerner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration knew, what is your response?
Your Honor, could we pause the video?
Yes, you can pause. Yes, sir.
Can I have just a moment to talk with the council, and then I think I have an objection.
A brief moment.
They all seem, I'm just pausing it right here because, when I try to talk over it, it won't let me talk over this doggone screen. But I promise y'all, like, the room for objection. Like, I don't get that. And here they go. See y'all, they about to right here. I don't know that I can't see all the stuff on Court TV. Let's see if we can if this sound can get better. Like, I'm so over it. Can you hear me now?
A brief moment.
There's a lot of, I'll say hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so there's a lot of, I'll say hearsay statements that are being propounded by Ms. Ferris, things that other people may have said. And so I understand videos is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, I would submit to the court that I believe those are hearsay. Any statements that she is alleging was made or declared by another party, I would submit is hearsay. And I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only consider my client's responses to those questions.
Judge, I would ask that we continue playing the video for now. and make a decision about whether there needs to be some sort of curative instruction after that.
So I will, again, continue to play the video, but I will grant defense motion that will give a curative instruction. So we'll prepare that when it's time for instructions of whose testimony they can consider in this video and the hearsay. All right, you may proceed, Mr. James.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Warner, was asking for. Like, just I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Warner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
Oh, the resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2:00.
She leaves at 2, so Ms. Lee.
I'm sorry, not 2:00, 12:00. And she comes back after McIntosh's dismissal for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Dr. Parrish, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduce over defense's previous objections, which were made contemporaneously. Being marked as Commonwealth 2.
And Judge, at some point, I will need to take a moment to get the full and complete video saved to a drive. And at that time, I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Farish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes.
And you do that for the school district?
Yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes.
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
Yes,
Do you have that document with you today on the stand?
I did.
Would you mind pulling it out? And did you bring that with you today?
Yes.
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
One moment. Yes, what's the objection?
Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
The court has already ruled on that. It is
We ruled on hearsay, we didn't rule on foundation.
Okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Ferris. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm going to request some on her foundation of knowledge regarding this particular document.
Okay.
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room because admissibility is not a factor for them.
Yes, sir.
And what's the basis for this again?
I don't think a proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not gonna allow this to run here at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022-2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes,
Official records?
yes,
Okay. And is what you've brought here today an official record of the school that was in effect at Richneck on 2022-2023 school year?
yes.
That,
Foundation established may proceed as objections overruled.
so I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
I'm sorry, I need to let
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression, or has attempted to carry out threats in the past, is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Parrish. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading weapons threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading weapons threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Parrish. That's all the questions that I have for you. Please answer any questions from defense counsel.
You may.
Well, still morning. Good morning again. All right, a lot to unpack. So just to go over, again, you are the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other.
You may.
Well, still morning. Good morning again. All right, a lot to unpack. So just to go over, again, you are the HR director for Newport News Public Schools, and you conducted an independent investigation of this whole incident. Is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that I didn't go into. It didn't.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm trying to figure out where the scope of objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, Ron.
And what part was your scope of objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all, Your Honor. Just,
All right, okay, but if you plan to get there, I think he's going to object.
well, we'll see what happens as we go along.
All right, you may proceed.
Okay. So you did conduct a complete investigation of this from the beginning of the incident to the end. Is that correct?
Correct.
Okay. And as a part of your investigation, did you do the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes.
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
Not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Richneck Elementary School?
You want me to describe, you're not asking me how many?
I'm asking you how many. How many different positions, sir? Is it?
I don't recall how many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Richneck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge. We're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying. She's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response?
Your Honor, she's testifying as to what she observed. So, she looked at videos. She's testifying as to what she observed on these videos. So I'm not asking to introduce these videos. I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objections. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be, by analogy, admissible?
Your Honor, obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or this video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I can, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Okay, 2 questions, or I guess 1 rule. Yes, she cannot testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I'm saying, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay, so again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there's been a lot of objections, and there were a lot of objections yesterday, and swirls all over, and sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay, other than Dr. Parker, were you able to determine the conduct of any other employees that were at Richneck Elementary on January 6th?
Okay, you don't answer. So your question was, she able to observe,
Yeah,
determine
observed the conduct behavior of other parties, other staff members at Richneck Elementary School.
Okay, and in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not produced. It's the same objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. If the court believes that she should not be able to testify as to what she observed by video, then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed.
Right.
Again, if it can't come into the front door, it cannot come into the back door. Next question.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes.
Okay. And so you're the custodian of this document, is that correct?
Correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response.
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes.
Okay. Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is the province of the jury to decide.
And your response.
Your Honor, I'll submit that to you.
I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I asked her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are problems for the jury, but how is the finding of this school investigation not how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is the Commonwealth has introduced the school handbook, the policies, procedures, and the crisis management. And there's been a lot of evidence and questions towards was that followed on that day. So that's a proper subject for cross-examination, and what the school found and all the school policies can come into evidence. We can have a curative instruction later if parties want that the school findings are not legal findings and legal conclusions for this case, and that is for the fact finders, and that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So if that supports basis, I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. So I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right. So regarding the multi-hazard crisis and emergency management plan, this is a plan for each individual school. Is that correct?
Correct.
Okay. And are you who's responsible for producing this document, if you know?
That would come under our safety security department.
Okay. Prior to this incident happening, were you familiar with this document?
I know that the schools have them. If you're asking if I'm familiar with this particular one prior to that incident, no.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
Through the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay, so this document would also apply to the teachers in the classroom, is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Okay. Is there anything in these two documents that prevented any of those four individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to. Okay. Did you hear what I said so far?
I heard you say you were going to go to page 60.
That's correct. Okay. And even when he directed you specifically to weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can ask us what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures.
All right,
all of them or few of them.
Response.
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed. With that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those four individuals, if they believe that there was a weapon, they should have.
Objection, judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about that.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
State your question.
Was it their responsibilities when presented with?
Was it whose responsibility?
Ms. Zwerner.
That's the same question, yes, that I sustained objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Ronna, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood. And I think you got something, Mr. T.
Oh, thank you. Good morning again, Ms. Ferris. Are you Doctor or Ms. Ferris?
Doctor.
Dr. Ferris. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting in certain sections.
Okay. So are you aware that the entire video was 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw.
Okay. And you were shown about 16 or 17 minutes, correct?
Yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets. It's the whole video.
Okay. So I'm gonna pull up the video, the actual video, the whole video.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the counsel not put that up on the screen until we've addressed.
That's fine.
Okay, he's objecting to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Did she say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And then we agreed that the jury would get the whole video for deliberations. So your objection, and what you're going to play is a part of this whole video?
Yes.
Okay. And so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and that the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has, which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basic thing, if the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth, the opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's the court's basis. You may proceed, Mr. G.
Thank you, Your Honor. And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Understood.
Okay, the whole name, not initials.
Correct, the
Okay,
whole
but
name.
how are we dealing with that, Mr. G?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid it.
We're talking about, again, audio and press coverage to the world.
I understand.
So you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay. You
But just to be safe, I'll just try to elicit the testimony from her directly, and then if I need to, I'll play the portions that I need to.
playing video or not?
It would just depend on her answers.
Okay, you might.
Okay.
Okay. But understand we have that
I
cautionary
understand.
instruction. We are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Farish, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to 2 other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I'll just refer back to my notes.
Ms. Zwerner, go down the path of asking about these 2 other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Farish, of what was going on regarding her conversations with Mr. Kovac and Ms. Zwerner, she also mentioned that there were 2 other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question. What's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, just go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Farish?
Yes, she responded to other issues.
Okay.
Students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay.
Or a student who was an eloper.
An
and
eloper.
something that happened.
Right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Farish, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection, Judge. Hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter entirely.
And her foundation for having that knowledge or information, so sustained.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct?
Yes.
You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
A basis for your objection?
Judge, we're gonna need to address this at sidebar.
Privately.
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay. According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember, the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection, can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Sustained. After you rephrase to clarify what you're referring to.
Okay. Well, I've already asked the questions. I'll move on. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
Yes. There's something in background noise. I'm not sure where it's coming from. I don't know if somebody's cell phone or, but if we could try to take care of that, it's very distracting.
Yes, I keep hearing it and it's distracting.
Okay, well,
Yes.
the sheriff will be on top of that. And I'm hearing it too, yeah, we'll work on it. All right, thank you. And again, it's 12:23, we're gonna keep going. Again, we'll try to go to 1 for lunch. But do any of the jurors need a break? Okay, they're good. Okay, I'll proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? May I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of
I
what?
don't remember her saying Zwerner said the student didn't have a weapon. I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember, if Ms. Zwerner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Zwerner never came to her and said that the student had a weapon.
Yes.
Okay. And everything that Ms. Zwerner related to Dr. Parker was about behavior of the student, correct?
Correct.
She also mentioned that they had, prior to this incident, that they had two incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to two other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they never search students.
Okay. And she was also managing state testing that day.
Correct.
Okay. Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go to? Oh, okay.
I just asked for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Mm-hmm. Okay. But you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. He can ask her what she believes today, now, but not what she said out of court.
I thought you said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question as I understood it.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, hold on before you answer. So, assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position, Mr. James?
He's feeding her the statement and just asking her to say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood, and your response to that, Mr. T.
Your Honor.
How is it admissible? What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll withdraw the question. Okay. No further questions.
Any redirect?
Yes, sir.
Dr. Farish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Richneck investigation report?
Yes.
And do you have that report with you right now?
Yes.
May I approach, Your Honor?
You in?
Sure. I believe you have a copy. Judge, I've provided to the defense counsel a copy of the plan. Do I need to wait?
Review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay?
Very good.
Okay, you may approach.
Thank you. Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Yes.
All right, so is that a fair and accurate copy of your complete full report of your investigation?
Yes.
All right, Judge, I move to admit that as Commonwealth's 3.
Your Honor, I'm going to object. This is the investigation, confidential Richneck investigation report that contains hearsay from other parties. It's not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about cherry-pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
Your Honor, we are on cross-examination allowed to ask about anything you want to ask about. It's launched in scope of the direct examination. This is a report that contains hearsay statements from other parties, just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video. Giving them a full report complete with hearsay is beyond the veil. It's not admissible.
Okay. Let me see the document.
Of course, may I approach the, oh,
You may.
the deputy has it.
Pass
Yes,
please.
of course.
Thank you. Appreciate you.
Your Honor, I would add that Dr. Ferris has not been qualified as an expert.
The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove this thing for myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. We're mad for amazing. Commonwealth District 3, Commonwealth 3. Rejected 1, rejected Commonwealth 1. Okay, you may proceed with the redirect.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm going to ask. Your staplers work just as good as my staplers. So I'm going to make a mess. Oh, here you go, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Your Honor, again, I'm going to object to hearsay. Those are statements coming from other people.
You asked the finding to be in evidence, findings in evidence. So noted your objection. Overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Ms. Zwerner, Ms. Kovac, Mr. Walls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll repeat Commonwealth 3 after them and refer it to the court.
Thank you.
Now, Dr. Farish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes.
All right, and that document is an authentic manual that provides all the policies that were in place at Richneck in the 2022-2023 school year?
The Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district?
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth Court. I'll have to retrieve it from the witness.
Okay, you may approach.
Your Honor, before that's admitted by the court, could I have a moment, please?
Yes, sir. You can still retrieve it, Mr. Jenkins, and you can pass it to Madam Clerk. I won't receive it until I get from the defense counsel.
The court already ruled that it comes in, so.
Oh, all right, so this is marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Richneck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted as Commonwealth's 5. May I approach the witness?
You may.
I just want to make sure our objections no continue.
Yes, yes, continuing objection, which was previously ruled on for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, Your Honor.
Okay, briefly.
Briefly, Dr. Farish. Again, the portion of the report that was just entered into evidence, your investigative findings, you were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct?
Correct.
And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker. Your finding is that none of them responded adequately, correct?
Objection, Judge. I think that misstates the evidence.
To respond to adequately, I do think it's a misstatement. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named? Ms. Werner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims and Dr. Parker?
Yes.
Okay. No further questions, John.
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took it away from you. Can I please retrieve Commonwealth's form? The Rights and Responsibilities Handbook.
And I can give you a page 7.
I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Mm-hmm. Principals and school security officers under the direction of a school administrator may search students and student property.
All right. So given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school under the direction of the school administrator.
Okay. And are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions, please.
Okay, so this, so that paragraph, it starts out principals and school officers. And then it, comma, under the direction of a school administrator.
Objection. I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes the principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, the same. Next question, Mr. Rogers.
That's all I have.
Okay, the status for this witness, may she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, Your Honor, we agree.
Okay, all right, so Dr. Fair, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony.
Yes,
Okay, and you'll be informed when you receive questions and when you're released from the witness obligation. Okay, thank you, ma'am, and why accept that you stepped in.
thank you.
All right, can we do another witness in about 10, or start with another witness about for 10 minutes or so? I want to use up our time.
Before we call another witness, I would need to step out, so.
Okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call another. The break will take 5 minutes, and then we'll only have 5 minutes of a witness before
Okay,
one
so
time. So
it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the jurors to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
there's nothing from the Commonwealth.
I think we're good.
Okay, so I'm gonna keep a tight schedule. Jurors report back at 2, attorneys report back at 2, and we'll get going. And there should be lunch back there. Again, jurors, your recess instructions. Do not discuss the case, do not research the case, do not allow anybody to discuss it with you. I will check in when we return. You are welcome to leave the building, or I think we have Subway for you today, if you wish to partake or of your own lunch. All right, Sheriff, we will escort them to the jury room, and we are in recess. Thank you.
We draw to the jury.
And the media can come and turn on their audio.
Oh my gosh, like you talking about a hard day at work, baby. This is a hard day at work. A hard day at work, baby. If you didn't think it was, it is. It's a very hard day. Like, it's so hard of a day. I don't even know if there's any testimony I want to go back and look at because they just got too many doggone objections. Like, yeah, I don't even think we got through no testimony. Who we hear from today? She was the only witness, right? Unless y'all want to go back and look at her interview. Now, that may be, something for us to look at. But other than that, like, oh my goodness, like, ew. Oh man, oh man, oh man. We've been live for about 4 hours. I promise you guys, if I go and I cut this down and take out all these objections and stuff, we only got 30 minutes of testimony. Yeah, I think that, I don't know. I think that I do think in some ways like the teachers might be, ganging up on Dr. Parker, like passing the buck. I honestly, God, I do not believe that Dr. Parker really thought that he had a weapon on him. I don't think anybody made it that urgent to Dr. Parker. I just can't see that. Like, her life was on the line too. What if he would have came in the room and pew-pewed her? I just don't see that. Like, I'm just like, I don't think mom was ever called to the school, goddess. I think the thing is that she did tell Amy that Amy could tell Abby that she can call the mom if he was being very disruptive or, in the class. But when it came back to, I think when they said that he may have a pew-pew on him, Dr. Parker, at least in that interview, she said it was like 140. She remembers it being like 140, and he was on a modified school schedule, and mom was, expected to be arriving very soon. Yeah, I think that was the problem, that they were kind of like waiting. Now, Abby did not say anything in regards to calling mom, for that matter of fact. Yeah, I believe that they passing the buck. I think that she's guilty, but I also think that they are guilty. So, I mean, although they're not all on trial, but what we have to definitely watch out for. Remember our trial in Texas with the officer. Like, I mean, he was guilty of being whatever he was and not probably going in there, but got 400 other officers that didn't decide to go in there either. So unless if it's not one for all and all for one, I don't want to hear none of that mess. You said normally you feel smart out though. Well, this ain't the trial, but look, this not the trial, Sammy. Because we are all confused. All we know is that all we done learned is that jurors be back there talking. You got to be listening for words, key words when they come out, when they say we, I, them, because that tells you a lot about what's going on for real. Because he sure picked apart them words. He was like, the juror got up here and said we. And I thought about it. I said, that's key, because you wouldn't say we unless you talking to somebody. You would say I. And so that was kind of like, okay. Talk to me. At different points of times, guys, I know, like, God's devil dog, I know that you having issues with your messaging. We do have open panels here. I am more than happy when we on any breaks, guys, for any of the newbies that's over here, to drop the link. And you are more than welcome. Sometimes the chat is moving fast, or sometimes you may be like God's devil, where it just don't like you today, but you got some stuff to say. I'm always willing and more than happy to drop the link for panel discussions regarding issues or cases that we are currently covering. That people, sometimes it's better to talk it out. So I'm always down for the cause. That's what I can tell you, because I know sometimes we got some things to say, and sometimes, the chat be moving. Sometimes it may not move as fast as 3,000 people in the chat, but sometimes you see somebody's thing and you want to message right in, and something have came through. So just keep that in mind for any of our lunchtime or break discussions. If you ever want to come up, I have no problem with dropping the link in order for you to come up here and talk to us. That was one of the main reasons why I kind of started YouTubing, is because I wanted to be able to talk to people. Like, I don't want to do all the talking. I want people to talk to each other, and not like where we got to be planning it out. Saturday, we're going to have a panel discussion about such and such case. We can just do the shit right there. I'm like, who's stopping us? We can do what we want to do. So there we go. So they are on lunch to 2:00. I know that means, I think they got a 30-minute delay. I don't even think they need a 30-minute delay, quiet as kept, but I know that the camera feed is 30 minutes behind. Why? I don't know, because we haven't been doing nothing but doing objections and stuff. Anyways. So let me get this up so I can make sure I can see when they come back into court. Yeah, and I think the only testimony that I would like to see over is her interview. Because remember, Dr. Parker is going to is supposed to testify, y'all. She's supposed to testify. I do have the young lady that just left, the doctor. She also testified in the civil trial. I don't know if y'all want to see that testimony before, but she did testify in the civil trial. Let's see here. Dr. Nina Barrett. Let me see. Let me see if I can see it right on the video. Yeah, and I get it. I just feel like, the principal got on the stand yesterday, guys, Devil, and um, she was there too, but nobody went and told her. And the principal testified. She said, "Look, I got an open door policy. If they do not like the response that they are getting from the principal, the assistant principal, they could have came in my door." Like, I mean, like, I promise you, I really, 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 and I wish these people would just be 100%. I can't stand when people don't want to keep it a buck. I just own your stuff. Let's stop backpedaling. Let's stop playing around. I don't think any of these teachers really, really thought he had a pew pew. Can you imagine if you really, really knew for sure that somebody had a weapon or the indication that they had a weapon, it would be nothing stopping you from calling 911. I wouldn't care if the principal knew, the parent knew, the lady down the street. I wouldn't care. I would be calling 911 and they're going to have to figure it out then. Like, we are not. I just really don't think they brought it to her like it was. And I'm not saying they had to say it was like a definite. Now, where I fought her at is that they came and told her that it was some type of idea or indication that he may have a pew pew. I think that at that point in time, she should have stopped and she should have went and investigated herself. But I think at the time that it was even brought to her that this was even it was really there. And what I say really there is, remember, they came to her. Amy came to her and was like, "Look, we believe he has some type of weapon. We don't know." They didn't know what type of weapon. They just knew he had something that he probably shouldn't have in school. Dr. Parker said, "Go search you." She said, "I'm gonna search his bag." Dr. Parker said, "Okay, sure, problem, no problem." Amy said that she went and searched the bag. She didn't see anything, but she got a text from Abby who said, "Hey, JT went back there and got something and put it in his pocket." Now, in the civil trial, Amy said that JT was playing on her because he told Amy, "Hey, I need to go get my shoes out of my backpack." And when he went to go get his shoes out of his backpack, allegedly, this is when he went and got the pew pew and put it in his pocket and went out there on the playground. So my question would be, and I think that anybody should be, is after Amy came back and told Dr. Parker, "Hey, I searched his backpack, he don't have nothing." Abby just texted me and said that she seen him retrieve something from his backpack, put it in his pocket. They are on the playground now. I think there at that point in time, instead of Dr. Parker saying, "Hey, we're gonna wait for his mom to get up here to check his person," I think at that point in time, that's when she probably should have made sure that she got up, right? But yeah, that's what I'm saying. Pretty Brown, like they sound like they all don't have a brain. Like that sound like a whole bunch of scarecrows. I mean, this could have been way worse. Like, I mean, he only had it bad for this one teacher, but it could have been way worse. And I don't know if I want to be around a whole bunch of scarecrows. Like, I need you, if you see something, do something. I do not need you to be on the stand talk about, I told her she do nothing. I did my job. That's Miss Amy. I did my job. Look, I told her she didn't do nothing. I was willing to put my life on the line and be pew pew for him for that. Yeah, the principal was there. The head principal was there. She testified yesterday, said she was there. They did a couple things, and she said she got an open door policy. So if they did not like Dr. Parker's response or her reaction, they should have opened her door. So that's what I'm saying. I mean, I think that Dr. Parker, I would say that I feel like, she could have did more. But in the same token, a lot of these teachers, I mean, I think I counted maybe 4 or 5 of them. They all dropped the ball. I mean, yeah, they did something. Well, yeah, Dr. Parker did something too. She delegated. Boom. She delegated. How about that? So now she at fault because she delegated. Well, everybody did a little something. So everybody did a little something, but why, I don't know. Yeah, it does. Real happy. Nobody, the principal, she was there. That was probably me. If you recall reading something in the chat, that's probably me. I'm sorry. I probably should stop doing inaccurate stuff. Like, I put in the chat, the principal was like, when she got on the stand, I'm glad I was on vacation that day. She was there. You probably looked at one of my inaccurate Sweet Pea trying to be funny and extra chats, but she was there. She testified yesterday that she was there. Hey, Kim. Yeah, the jury winning the case. That's right, Kim. We don't know what's going on. And what that sounds like to me, y'all, it sounds like it's going to be a hung jury. I think this is going to be a hung jury. And even if it's a hung jury, I think that we're going to have a appeal or in regards to anything. And what's not disgusting about this whole case? Man, the ex-principal, Dr. Ebony, she is facing more time than the mama. Who had the weapon in her home, didn't have it properly secured. She is facing more time than the mama. Make that make sense. You talk about that ain't even my offspring. That ain't even my child. And you telling me I gotta face more time than the mama? Man. Yay, Kim, welcome to the club. Like, can y'all imagine? She facing 8 counts. 8 of child neglect for each bullet that was in the weapon on a woulda, coulda, shoulda idea. Mom only faced 1 count of neglect. Is that why not wild? I mean, just thinking about that, I'm like, not guilty. And I think that's why one of the jurors' questions, y'all, number 38, what are the 8 felony counts? They probably trying to understand and reconcile this in their head too. Like, well, why do we have 8 felony counts? We only know 1 person that got hurt, and that's Dr. Abby. So I'm assuming, that was the teacher, Abby. So I'm assuming that they're going to explain that to the jury. I agree with the mistrial in regards to what the defense is saying, because it's clear that the jury is not putting all this together in regards to these timelines. Like, they're asking questions. time of recess to the pew-pewing. Like, how much time allotment did Dr. Ebony have? I mean, this is very important because remember, Amy says she walked to the playground, right? Because they're on recess. Amy says she went to Dr. Parker's office, explained that stuff in regards to he didn't have anything in his bag or whatever the case may be. Amy said she went to the playground and she explained to Abby that she can call the mom or whatever. My question is from that time period to the time they got back from lunch, you know, Amy wasn't worried about it was such a threat, or Abby then told me that, hey, he might have put the pew-pew in his pocket. Amy wasn't worried enough to separate JT from all the other students or bring JT down there to the office. She wasn't that worried, y'all. She was worried about testing. Y'all better talk to me. I don't get this. She wasn't that worried. And you know, the defense asked her, he was like, so you had the authority to like separate kids, right? If you feel something is going on or if a kid is being dysfunctional. You know what, Amy was worried about testing. Yeah. All right. That's very important. It's very important stuff. And people are not thinking about, like, you gotta, and I think that when they get up here and they talking and they trying to present this stuff and it's very one-sided, but everybody had a responsibility. Like, this could have been prevented way before anything. Like you can't have it both ways. And that's how Amy wanted to have it yesterday. She wanted it both ways. And that's why she's so aggressive when the defense attorneys are questioning her. And that's how she was in the civil trial. I need y'all to know that. We watched her testimony yesterday in the civil trial. It was like for the prosecution team, she might as well go. I'm telling y'all, yesterday when she got off the stand, she went over to prosecutors like, where should I sit? I'm exaggerating, but shit, she might as well have said, where do I sit down? I'm on y'all team. I'm on y'all side. You know, I try to make this stuff humorous, but I'm telling y'all, I'm telling y'all all around, like, it could be pretty like some bull, like some bullshit, in my opinion. And that's not to say that Dr. Parker shouldn't have got up. I'm not saying that. All I'm saying is that it was other things that people could have did. And it's just not fair to me that, you know, you take the responsibility and you delegate, right? So everybody acting like she didn't take no action. Well, just because she didn't get up out of her seat doesn't mean she didn't take any action. If y'all gonna call her the boss delegates. She delegated to Amy. Amy was so worried about the damn test, like she didn't know. She want to run around here like she just doing so much. Yes, Amy, I said it. She can take that. She can take that because yeah, I said it. Amy, my girl, bye. Like, I cannot with you. I mean, and she's so like defiant and stuff. And I'm not even blaming the teacher, you know, the teacher that got injured. And that's why the defense is trying to hammer home, like, well, okay, you could have did this, right? Because it looked like from what we can tell, his only beef was with Ms. Warner. Okay, so if they would have even separated him from the class, like when Amy asked to see his bag and he was defiant about not seeing his bag, y'all know that she testified saying that she felt like JT had played her because this same bag that could have had all this stuff in it that Miss Amy was going to investigate He wouldn't let her check that bag, but then in the same token, she allowed him to go get shoes out his bag and then want to get on the stand talking about he played her. Well, yeah, okay, I guess he did play you. It's only one or two things could be done. Did he played you, or you really didn't believe this young boy had a weapon? Nobody's thinking a 6-year-old has a weapon. So I just want you to own that part of it. And just own that you didn't make it that urgent that nobody ran to Dr. Parker's office and said, he got a weapon. Please go search him. Nope, they did not do that. So, yeah, that's my problem. Damn, Amy. Yeah, so y'all let me know. Hey, Angela, y'all let me know if there's anything out here as far as the testimony y'all want to rehear while we on break. So y'all can like hear like the little tidbits that I'm hearing in this, because I think it's very important. Guys, Devil said, I don't think in serious situations like this, you don't depend on delegate, and principal needs to be notified and get eyes on the situation yourself. And you should take him if she thinks he has it. And you should take him if he has a weapon. Yeah, and that's the thing. Like, we're not just talking about the teachers' lives. We're talking about their lives too, right? So I can promise you, guys, Devil, if me and you are in a room and I think somebody got a weapon and I really, truly, truly believe that, there is nothing that you can do to stop me from taking action on my life, my livelihood. I ain't even, look, it's one for, it's every man for themselves. Like, I'm thinking about me versus to anything, like, so it just amazes me how they get on the stand and everybody's trying to act like it was just so definite. It was just so, he had it. So everybody knew he had it. When the two little girls walked up to her and said this, she didn't believe it, right? Clearly. Because if she believed it, then when she sat next to him and he had the bag, she could have separated him from that bag. When he ran up to her in the hallway and hugged her. Remember, this is her testimony. She could have separated him. But she didn't. You ask me, I think Amy should be facing charges. No. No, that's just my thing. I think they all should be like that. Yeah, like, bye. So, I don't know, y'all. And if the jury is thinking anyway, like how I'm thinking, yeah, they're going to have a problem. They're going to have a problem. I just have to be honest. They're going to have a problem because it just don't work like that, baby. It just don't. It just don't. She's so something else, boy. She make me, well, I have to call her that because boy, her testimony yesterday, I think I did. I cut it where y'all probably wouldn't see the she is something else, boy. I think I clipped it enough. Let me show you. I'll put it up here. I think I did it enough where we don't have to do all the sidebars because I was trying to take all the objections out. But honestly, guys, with this kind of case, even though I went through yesterday and I took like all the objections for the most part and stuff out of it and edited, it's almost that's kind of like what is making this case. What comes in, what's not allowed, what's being said, and typically we know that in the pretrial, we have pretrial motions, we have court, we get to know what's not going to be brought in. But they didn't do that. They doing all this live in court as we going along. Yeah, they on lunch right now. Yeah. Yeah, I don't know what they can do in regards to dropping the charges, but just thinking about the whole thing, the mom facing all these charges, the mom you know, she ain't even got that many dang on charges, man. Ain't nobody got time for that. Let me show y'all. I think I cut her stuff down enough. I mean, even with opening statements, I'm gonna just show y'all the I'm gonna show y'all the actual wait 11 12 1 2 they'll be back in a minute. I think I know they said that we got a 30-minute delay. Well, maybe not to 2:30. We probably got about 30 more minutes because I think they got a 30-minute delay with their streaming. But let me show y'all this. I'm gonna show y'all her testimony from yesterday. And y'all tell me what y'all think. Cause like I'm like, girl, bye. I'm not buying it. Let me see. How do I click? Let's get on it. Amy. Now watch her demeanor on how she is on direct. I'm telling you, she just need to go over there and sit with the prosecution team. She was. I mean, don't get me wrong. I like it for the entertainment purpose of it. But when we talk about somebody facing 40 years, y'all know she facing 40 years unless the judge decide that she want to allow it to run I don't know. I guess concurrently or some stuff like that. But look at her. She getting in her chair. Amy, look at her. Look at her. She ready. Run it up there to the stand. Girl, she can't wait. This is the first witness after Abby.
Okay.
Good morning. Could you please tell us your name?
Amy Kovac.
Could you spell your last name for us?
Kovac.
Thank you. Ms. Kovac, how are you employed as of today?
I work with Newport Public Schools as a reading specialist at Newport Park.
All right. And then I want to take you back to January of 2023. Were you also a reading specialist at that time?
Yes.
And where were you working?
Richneck Elementary.
How long have you been employed as a reading specialist total?
12 years total.
During your time at Richneck, did you know a student, and I'll remind you that we're not using any student names, so please keep that in mind, but did you know a student by the initials of JT?
Yes, I did.
How did you come to know JT?
Dr. Parker at the time had put him on a modified schedule, and I was his one-on-one teacher for reading during that scheduled time.
Okay. Do you know from your own observations and interactions why JT was on a modified schedule?
I had heard he had. I was on the modified.
Hold on one second. Let's go back one. And how this works procedure-wise is they have checked, the other party gets to respond, and then I'll make a legal ruling, and then I'll let you know what to do. So, and just explain it to you. Okay, so defense is objective, your response is necessary.
Your Honor, if there is hearsay there, I'm not trying to elicit that, so I'll try to rephrase the question. Ms. Kovac, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified
schedule. Okay, understood. So you started working with him in a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So originally the schedule, he would come to school at 9:20, get off the bus, and our counselor, Mr. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45, and for like 15, 20 minutes, do reading with me. And then Mr. Rawls would take him into Ms. Warner's classroom. And then he would leave around, I think, like 10:40, 10:45, get his lunch and then go.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023. Did there come a time when you were in the office that day with Abby Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because two girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for...
See, I'm pausing right here. Do y'all hear that? This is Amy on a stand, right? At 9:30 in the morning, Miss Warner is in the office, correct? Y'all make sure I'm not missing nothing. Amy says at 9:30 in the morning, she tells Miss Warner, keep an eye out on JT. Because two little girls told her that JT had a weapon. Now, remind y'all, if I'm not mistaken, I rewind this because I need to understand. This is at 9:30 in the morning. The incident didn't happen to lunch. Y'all better talk to me and tell me what's going on here. I'm gonna rewind it because I need to understand. I don't understand this.
There, I'm not trying to elicit that, so I'll try to rephrase the question. Ms. Kovac, did you have any personal interactions with JT yourself that led you to believe that he needed a modified schedule?
Not before the modified
Okay,
schedule.
understood. So you started working with him in a modified schedule. When was that?
It was in early October.
And tell us a little bit about how the schedule worked.
So originally the schedule, he would come to school at 9:20, get off the bus, and our counselor, Mr. Rawls, at the time would pick him up off of the bus and get him breakfast and set a goal for his day. And then he went down to Mary McBurnett, our K2 special ed teacher, where she was to do a social story. And then he was to come to me around 9:30 or 9:45, and for like 15, 20 minutes, do reading with me. And then Mr. Rawls would take him into Ms. Warner's classroom. And then he would leave around, I think, like 10:40, 10:45, get his lunch and then go.
And you've mentioned Mr. Rawls. Do you know what his title was there?
He was the school counselor.
Okay, thank you. I want to speak to you about the morning of January 6, 2023. Did there come a time when you were in the office that day with Abby Zwerner and Dr. Parker?
Yes.
And while you were in that office, did you, based on what you heard in that office, did you have concerns?
Yes.
Later in the day, did you tell Ms. Zwerner to keep an eye on JT?
Yes.
Why?
Because two girls had reported to me that he had a gun in his bag.
Okay, what's your objection?
May I lay a foundation for the potential use of an exception, Judge? You've indicated, I believe, that two girls spoke to you. We'll hold off on what they told you. Can you describe those girls' demeanor or behavior at the time they're reporting it to you?
Yes, I was walking past the room and the two little girls had come out to me and said that JT.
Oh, wait, hold on. Before you tell us what they said, what I want to know is how they appeared to
They
you.
seemed to be scared and worried.
Okay, what did you see in them, what in their bodies or their faces that made you think that?
The actions of them coming close to me, wanting to get my full attention and to let me know, and their faces were kind of like expressive to show worry and concern.
Okay, and eventually they do tell you something, again, without going into what they said. Do they relate to you about something that has just happened, that they've just seen in the minutes before? This is to establish a foundation to use the hearsay exception, Judge. It's foundation.
Hold off on answering. Let me hear the full question, then I can decide on the objection.
Yes, the question is whether the report she receives is quick in time to when she received it. In other words, whether they are reporting something that happened within the last minute, because that's a foundational question for the excited utterance exception.
Mr. T.
I think that's clearly leading. He's asking for, she has not even testified anything about what they said or how, she testified that they seemed scared or whatever, but he's getting her the answer by asking that did they tell you something that had just happened right before you came in contact with them? I mean, that's his testifying.
Okay, let me pull out the excited utterance.
Rule 2803(2).
And you are still under oath. We're going to answer some questions outside the presence of the jury. You may ask you some questions. You may proceed, Mr.
When we left off, you were telling us about two girls running up to you. Could you please tell us what they said?
They said that JT had a gun in the back.
Okay. So upon saying that JT had a gun in the back, could you describe their demeanor in saying that?
They came up to me, they were kind of, like nervous and worried and wanted help.
Okay, Judge, I think that lays the foundation for her to say what the girls told her under the excited utterance. Standard to be applied at this stage.
Yes, sir.
The standard in the site.
I'm sorry.
There's one other thing.
Okay. Yes, sir.
How do you know?
I'm sure you kind of proceed with your direct examination.
When we took the break, we had spoken about the question was, what made you warn Dr. Parker, right? And do you remember answering about what did? Let me ask you that. What made you warn?
I don't object. There's been no testimony. I believe you just said warn Dr. Parker. There's been no testimony of that.
I'm sorry. I apologize, Judge. Let me withdraw that. That's correct. I need to rephrase that question. That's correct about that. The question was, at some point later, do you tell Ms. Zwerner to keep an eye on JT? Did you?
Yes.
Okay. And what happened to make you get that warning to Miss Zwerner?
So the girls had reported to me, had come up to me as I was passing, right after they came in, to say that he had a gun in the bag. And I went into that room with the children and to him to try and see what he would say, to see if I could help and figure out what was going on. Because him and I had a good relationship due to the modified schedule.
Okay. And without telling us what you or he said, did you at that stage get any information about a gun out of him?
I told him the rules of school, that we cannot have any guns in school. We cannot have any type of weapon in school. And I asked him if he had a gun in the bag.
Okay.
And then we went on with the lesson. He was acting very weird that day, out of character, balled up. I just sat quietly by him. His bag was by him. I said, give me that bag. He said, no one is going to touch that bag, which was very out of character. He also was talking about one of his friends.
Okay, so here we go. Let's break this down. Amy was approached by two young ladies that said, hey, JT may have a pew-pew in his bag. He got a pew-pew. Amy goes into class, right? And she's sitting down and she's trying to inquire in a slick way, trying to see if JT got this pew-pew. This is the first strike against Amy, because at that point in time, she should have separated him from the bag. She should have been taking him to the office, in my opinion. Here we go.
At the time, or
You're not. Here's the objections to what you said. What JT said.
So sustaining is kind of the narrative. Can you ask another question?
I can. Thank you, Judge. After you had observed these things with JT, did you talk to Dr. Parker?
not at that moment.
Okay. What did you do as a result of what you observed?
So what I observed is it was time for them to do their assignment. And so JT asked for some school supplies. So I went up to Ms. Zwerner and I said, he needs these school supplies. And I asked her when recess was, that I would be back when recess was, and I was going to check that back.
I see. At that point, did you go and speak with Dr. Parker?
Yes, I did. At that point, I left the room right away and went to Dr. Parker's office, and I reported.
Hold on just a minute. What, at the time that you go to Dr. Parker's office, do you know what Ms. Zwerner's class was going to do?
They were going to head to recess.
Okay. And when you went to Dr. Parker's office, what did you tell Dr. Parker? Absolutely not. It's being offered for the fact that Dr. Parker was given the warning, not for whether the warning itself is true. It's not being offered to show that there is a gun. It's being offered to show that Dr. Parker was told there was a gun.
Again, the truth that there was, that's what you're saying.
Very simply, what did you say to Dr. Parker?
I went to Dr. Parker and I told her that two girls came to me and said that JT had a gun in the bag. And I told her that, that's what I told her, that I was warned that he had a gun in the bag. I told her what I did in the classroom, that I sat in the classroom with him, that he was acting very weird that day, out of character.
Okay, and so you relayed that information to her. Is ultimately, was there a discussion about any additional action that would take place related to the bag?
I told her that when they go to recess, that I was going to go back and check the bag.
Okay, did Dr. Parker respond to that?
She had just acknowledged it with like a nod.
Okay. All right. So what did you go check the bag?
At that point, I left. We were doing makeup state testing, so I went to my office, which is past Ms. Warner's room. And Ms. Warner had texted me at that point.
Okay, I'm gonna have you hold off right there.
Okay.
So just jump with
So
me.
I went-
Okay. Did you at some point go to the room?
Yes.
Okay. And
Yes.
what
So
did
I
you
went-
do?
When they were at recess, I went back to the room, I checked his bag. Inside his bag was a puzzle, a math book, a little coin token, and then a calculator in the front pocket.
Okay. And what happened next?
After I checked the bag, I went back to Dr. Parker's office to let her know that I checked that bag. I told her the same items that were in the bag that I had seen.
Okay. And what did you do next?
After that, I went back and I went back outside to Abby and the class that was outside at recess.
Okay, I'm going to pause you right there. While you're outside at recess, without saying what anyone said, were there discussions among the teachers?
There was only her outside with her class at that time, and then I came outside at that time.
Did you and Abby talk?
Yes,
And had you and Ms. Werner, again, without saying what the content was, had you and Ms. Werner also communicated by text message?
yes.
Okay. Now, as a result of those communications, again, it doesn't matter what was said. What did you do next?
So from the result of the text,
Mhm.
I then went and checked the bag. I then went and reported the second time to Dr. Parker. Then I went outside to speak to Abby to see if he would come to me because of what she had said in the text. So he was behind the rock wall, did not come to me. And then I told her again,
But wait, you told who?
I told Abby,
Okay. Are there two conversations with Dr. Parker?
there were two times I reported, and then one time I was in the office. And then Dr. Parker had told me that I could tell Abby an action to do if he misbehaved.
Okay. What prompted the first time you talked to Dr. Parker briefly?
The report of the gun.
From the girls?
Correct.
Okay. Briefly, what prompted the second time you talked to Dr. Parker?
The message that I received.
Understood. In the second conversation with Dr. Parker, what did you advise her of?
I advised her that the weapon in discussion was now in his jacket pocket.
And that was your belief?
That was my belief.
Okay. You mentioned that you had been at recess. At recess, did you have an opportunity to see JT?
I did not.
Okay. According to your understanding at the time, what was the protocol for teachers or faculty members to follow when they believed there was some sort of crisis developing?
According to the Richneck handbook, we were to report to our administrators.
I'm going to object. Hearsay, talking about something in the handbook, being not true.
Response.
Your Honor, I just asked if she knew it, and it is knowledge that she had. She's not reading from anything. She doesn't have the handbook, so she's just saying that she has that knowledge of the policy.
I will have to answer.
Ms. Kovac, I want to take you to the moment on January 6th that a gunshot has happened. Do you recall that moment?
Yes.
Okay. And what was your first thought and what did you do?
My first thought was he had that gun, he shot it, and I walked in that room. He
By-
needed me
By in that room,
In
you,
Abby's room, room 11.
okay.
He
And-
needed me.
Okay, hold on. Let me walk you through it. When you walk into the room, what do you see?
I walk into the room, Abby is to my left, and I see blood on her leg. So I know she was hit. To my right, the children are running out and screaming, going across the hall to the open door. And he was standing right in front of me, arms crossed, legs spread, and cocky.
Okay. At that stage, do you see a gun anywhere?
I do. It's on the left, my left, slightly under the reading table.
Did you go to justice?
I went.
I'm
straight-
sorry, JT.
Mhm. I
I
went
apologize.
straight to him. He did not resist me. I took him by the wrist because I knew he shot left-handed. He's left-handed. I didn't want to ruin the gunpowder, watched enough shows. I took him to the front of the room. I sat in Abby's chair. I put him in between my legs and my arms, and I picked up and I called 911.
Okay. And then after you did that, do police eventually arrive?
Eventually, it felt like eternity.
Yeah. So when they arrive, what position are you in? Are you still that same?
I'm still in that same position. So we were facing, like the phone is here, and we were facing as the police were coming in.
Okay. And as the police are coming,
Okay, just so y'all know, they are still on break. They still on break, but I want y'all. They haven't started the live feed, but y'all listen to this testimony because she just sounds like she just full of crap. And I apologize for this because now you want to put on your big girl drawers and you want to be approaching the gunman. Like, what are we doing? But you was afraid to take the bag. Y'all make this make sense to me. Now, I mean, out of all this stuff, now you want to be approaching him when he got a pew pew in his hand. And you want to be wrapping your arms around him. And then we get all this extra stuff in because she didn't say this stuff in the civil trial, but we'll get to her extra stuff in just one moment. But what? And I watch all the crime shows, and I know they want to get the gunpowder residue off his hand. All right, lady. Okay, cool. You had the wherewithal to think about all of this stuff. But you didn't think about any of these things leading up to it. As soon as she heard it, like the girls ran up to you and said he had something. He went out on the floor and see what I would like to know. How long after Miss Warner, Abby, came back to her class with said individual, JT, did this happen? Because if he was behind a brick wall on recess and he wouldn't come to you and it was reported by Miss Abby that he had put something in his pocket, why is nobody trying to get him? This is the second time, guys, that Abby, Miss Abby, Amy, they all know that this is possibility of what he has. Nobody's trying to separate him from anybody. I would really like to know how long from the recess time when they got back into that class, what time did this all happen? Now, I want to say, don't get me wrong, I know that in Dr. Parker's thing, she said she looked at the clock and it was like 1:40. So unless they may have a late lunch or something, depending on how that goes. But I mean, he didn't got mad. He did threaten some girls, some kindergartners. They had all these warnings, and it wasn't just Dr. Parker knowing all these warnings. It was these people, and they have the authority to separate him. She admits that on the stand reluctantly. She didn't want to. So, I mean, like, I almost feel like it was a whole bunch of things that this one right here, Amy, could have done. Like, you can't have it both ways. Like, I mean, she admits that she was scared of him. And that's why she didn't grab the bag. So, I mean, now you walking up to him and you put on your big girl drawers, talk about a bubble was around her. I ain't going out a bubble. Girl, bye. Now she done put on her big girl drawers and now she walking towards the guy with the baby with the pew pew. Oh my goodness. Y'all listen to this testimony. They still not back, just so y'all know. I'm keeping an eye on it.
In to the room, what is going on with JT? What is he doing?
You're not going to object to relevance at this point. It's not relevant to these proceedings at this point. What happened after the gunshot, or whether Dr. Parker is guilty of anything. We've gone beyond what's relevant in this communication.
Your Honor, the statute contemplates the event.
The objection in terms of it's part of the incident. And
Okay, and if he was okay, and we were both.
2 hours after this incident, are you going past that?
Not with this witness, Judge, but with children and families that experienced ongoing effects from the neglect, but not with this witness.
And we'll take that up at a later point. But yes, you may continue with this witness and objection rule.
When police arrive, that's the part we're talking about. What is JT doing?
He is in my arms, and they asked me if, I was okay, and if he was okay, and we were both okay. He became more agitated and cussing up a storm. And eventually, he was just spewing cuss words, stating, that he.
No, I'm going to again object to relevance here. And also the fact that this testimony is really more prejudicial than probative of any element of the offense.
I think the court has already ruled on that.
We didn't talk about prejudicial versus probative. You want to respond to that portion of the objection? That's a new objection.
Sure. All of the Commonwealth's evidence is prejudicial by definition. The question is whether it is probative. Probative is another word for relevant. Dr. Parker is charged with neglect of children.
Agitated, he was cussing. I told him Mrs. Kovac does not like that language. He turned, gave me the finger, and then when I turned my head back, he punched me. My glasses went off, and I said that I was done, and I turned him over to him.
Okay, and at that point, did you leave the room?
At that point, I did leave the room.
Okay, thank you. Now, Ms. Kovac, if you know, were police wearing body cameras while they were in there that day?
I knew that the one police officer said that he had the body cam on and got the whole transaction and my assault on the body cam.
If I were to show you a still picture from that, would you be able to recognize yourself and JT?
Yes.
Judge, I'm going to ask permission to show that to the witness at this time.
Okay.
And you approaching the witness?
First, I'm going to show it to defense counsel, then approach the witness stand until I've laid a foundation.
They didn't show it to us.
Yes,
but this is her start of her cross. It's still not back. Still not back, y'all.
Okay. Name is Amy Kovac?
Yes.
And I believe you testified that you have been a reading specialist for 16 years? 13 years. And how long have you actually been a teacher?
33 years.
A lot of experience in the school system.
Correct.
Is that entire time with Newport News City Schools?
No, the first 10 years were in Queen County. I've been with Newport News for 23 years.
Okay. All right. And would you agree that you had actually spent a lot of time with JT prior to this incident?
On the modified schedule, yes. So from October through January.
So you were used to his ups and downs, is that correct?
Correct.
Okay. He had good days?
Yes, with me.
Okay, and obviously, even prior to this day, he had some bad days.
Correct.
Would you agree that the Wednesday prior, just immediately prior, he had a bad day?
Correct.
Were you there to see and observe his behavior on Wednesday?
In the classroom,
After the classroom incident?
I was in the office when he was brought up.
Okay, all right. And are you aware who brought him up?
Mr. Ross.
Okay, all right. Do you know why he was brought up?
He didn't tell me then. I called for the buses at that point.
Okay, but you knew there was an incident in the classroom, that he was brought out of the classroom, is that correct?
I knew that he was in an incident and was carried to the office.
Okay, all right, okay, good. All right, so would you agree that it's the teacher's responsibility, primary responsibility, to make sure that the students in their classrooms are safe and protected from any harm?
It is the teacher's responsibility to teach the children, to have a schedule for the children, and to handle disruptive behavior, not excessive behavior, is my understanding.
Okay, so you would agree that if there's a disruptive student in the classroom, the teacher has the authority to remove that child from the classroom?
She can usually call for help. That's what I would do.
So you're saying no, a teacher cannot remove a student from the classroom for disruptive behavior?
I mean, to another classroom. It just depends on what the classroom plan is and the school's rules are.
So yes or no?
I don't know.
You don't know? Okay. All right. Have you ever removed a student from a classroom for disruptive behavior?
In my classroom as a general ed teacher?
Sure.
Or as a reading specialist?
A general ed teacher?
Yes, I've moved them to another classroom.
Okay. All right. You would also agree that a teacher has the ability, if a student is disruptive, to take them down to the administrative office?
If there's someone to watch their class if needed.
All right. So obviously, you don't want to assign any blame or responsibility for the classroom teacher for JT's behavior on that day. Is that correct?
Objection. This calls for speculation. Is an opinion about whether she wants to assign something to somebody.
I'll let the court rule on it.
This cross-examination, he's allowed to fully vet the witnesses.
It's not my place. I mean, I don't know what, I can't think for somebody else. I can only think for myself.
Okay. All right. So let's start when you first became aware that there may be a problem with JT. Okay. I believe it was the incident with the two young girls. Is that correct?
For that day?
For that day.
No, that was not the first time.
Okay. What was the first time that you had any kind of indication that JT was having a bad day?
When Ms. Warner came in to report that he had been acting up in the lunchroom, and she was reporting to Ms. Parker. Myself and Ms. Harris were in there because it was testing. We had just returned our tickets. Dr. Parker did not look up at her, did not acknowledge her.
Okay. You did not observe this behavior yourself. This was just something.
I did observe that behavior.
What observed? What?
Not Justin's behavior.
That's what I'm talking about. I'm talking about JT's.
But Dr. Parker and Abby's behavior, I did observe.
Okay. All right. And then you had the encounter with the two young girls. Is that correct?
Correct.
All right. And so it sounds like, based on your testimony during direct examination, that you believe the girl's assertion that JT had a gun. Is that correct?
Correct.
Okay. So obviously, if JT had a gun, then he presented a danger to the students in his classroom. Is that correct?
Correct. Correct.
Okay. All right. So you went to investigate that. Is that correct?
I walked into that classroom to speak with him.
With the belief that he had a gun. Is that correct?
With the belief that there was a possible weapon.
Okay. All right. And so, and you observed that he was acting off. Is that correct?
Correct.
Okay. You, along with his teacher, had the authority to remove him from the classroom. Isn't that correct?
We had already told her that
I'm talking about your authority.
you had the authority, along with Ms. Zwerner,
I
to.
don't know.
Okay. All right. But even with you indicating that you believe that he had a gun, you spent some time with him, and then you left him in the classroom, even though you believe that he had possessed a gun. Is that correct?
I left the classroom to report as required by my school.
If a student had a gun, don't you believe it's required that you separate that student from the other students so he doesn't present a danger of harm to those students?
Objections been asked and answered 3 times.
Your Honor, I'm just trying to make sure that she clearly indicates what her responsibilities are regarding the safety of the children.
Yes, one last time. For the safety of the children, I did not remove him at that point.
All right. So then you said that you actually spent some time on the playground when JT was with his classmates. Is that correct?
I went out to the playground, did not spend time. I was testing and had to get back.
But you believe that he had a gun on the playground. Is that correct?
I'm not sure what kind of gun, I'm not sure what kind of weapon. I had not seen it myself. I only heard the reports and I reported as required.
But you said you believed it was a gun. Is that correct?
Because the girls reported.
And you believed them?
Any report of a weapon in a school, I'm reporting, and I did.
All right.
More than once.
Is there a possibility that you thought it was a toy gun versus a real gun?
I mean, my personal thoughts are my personal thoughts, so.
Did you express to anybody that you thought it was probably a toy and not a real gun?
Yes, after the incident, the police have it on police cam. That was my thoughts while I was in shock.
Okay, so you believe there was a real gun, and then you left the other
I
student.
did not know if it was a real gun or not. When I was in the room.
So you didn't believe that he had a gun.
Objection, Your Honor. He's misstating her testimony over and over within his questions.
Your Honor, she's trying to have it both ways. She indicated on direct examination that she believed he had a gun. Now that I am assigning her responsibility to her, she's trying to say that, well, I don't know. What I believed at the time, she's acknowledged that she did tell somebody that there was a toy gun. So I'm just trying to narrow down whether or not she believed it was a gun or not.
It's that she has already said the answer. She has already said that it could have been any kind of gun she didn't know. And he keeps restating her testimony differently than that. He keeps saying, you believed it was a gun. And she keeps saying, I didn't know if it was a gun.
I think he switched to her stating something different purportedly on the body cam that now says toy gun. And again, strong cross-examination, vigorous cross-examination is fundamental of our justice system. So overruled, you may proceed, Mr. Rogers.
Your Honor, may I address one other issue?
Yes.
I'm hearing in the courtroom gallery commentary coming over my right shoulder. I just think the gallery needs to be informed that they're not.
Okay, and I can do that. And I heard something, I just couldn't tell the direction. I need absolute silence from participants in the courtroom. We cannot comment, we cannot bolster, we cannot suggest our opinions in any way. Please govern yourselves accordingly. This is an open public proceeding. If people are disruptive, they will be asked to leave. Comments are considered disruptive, and I can't close this courtroom. I'll ask everyone to govern themselves accordingly. And I think the sheriff will start keeping an eye out for that when he was. So sheriff, if anybody making noise, please escort them out. Thank you. All right, please proceed, Mr. Rogers.
Thank you, Your Honor. So it sounds like now you're saying that you weren't sure if he possessed a firearm. Is that correct?
What I'm saying is the girls reported that there was a gun.
And you believe them?
And I.
Objection.
Yeah, let her finish her response, Mr. Rogers.
I acted on the report. Children were 6 years old, first grade. I acted on the report. I went to see what was going on with him. I did not look in the bag. I did not touch the bag. I was in the room. When I left the room, I went and reported to my administrator.
Did you leave that?
Are you finished your response? Okay, next question.
Did you leave that room believing that there was a gun?
I left that room believing that there was something in that bag.
Something that potentially presented a threat of harm to those children.
This is ask and answer, Mr. Rogers. Next question.
All right. And then let's talk about the playground. Same thing, right? You knew that JT was out on the playground, is that correct?
Correct.
All right. You said that you didn't visually see him yourself, but you knew he was present, is that correct?
Correct.
Okay. He was out there with his classmates, is that correct?
Correct.
All right. Miss Zwerner, his teacher, was out there, isn't that correct?
Correct.
Okay. There was nothing that prevented you or Miss Zwerner on that playground to separate JT from the rest of his classmates. Isn't that correct?
No.
All right. So you said that you searched his backpack. Is that correct?
Correct.
Okay. After you searched his backpack, did that dispel any fears that you may have had that he possessed a firearm?
No.
Okay. So you continued to think that he potentially had a firearm. Is that correct?
Something. He had some kind of weapon.
When you say some kind of weapon, are we talking?
We're talking gun because that's what the girls reported. I did not know what was in that bag.
So are you holding out the possibility that it's a toy gun?
I'm not sure what it was.
Yes or no?
It could have been, yes.
All right. So if it was a toy gun,
We still report and we still investigate.
I got you, but it's not a toy gun is not a threat of harm to the children. Isn't that correct?
If there is a report, it is required by the state that you report.
Do you
And
understand
I
my
did
question?
report. I do understand your question.
Okay, does it?
Okay, hold on, for everybody. We're gonna lower the temperature. So the objection would be non-responsive, because she did not answer your question. She answered a different question. Can you repeat your last question, Mr. Rogers?
Do you believe that a toy gun presents a threat of harm to those students?
It couldn't. Yes, yes, it could.
Okay, explain. How in the world a toy gun could present
A
a...
BB gun, a water gun.
I said,
any kind.
my question was...
She answered the question. What's the next question?
Okay. So you consider a BB gun as a toy gun, is that correct?
It's a gun. You report for any type of weapon. I report it.
All right. When the just going back a little bit, when the girls made this report to you, did you take them down to the office to speak to administration?
I did not.
All right. Do you think it may have been important to take them down to the office to?
I did the actions that I did in that day, and I cannot look in retrospect.
Okay. Who gave you the authority to check the backpack?
According to the crisis plan, we are allowed to. We just cannot check your body without permission from the administrator.
Okay. So did Dr. Parker give you the authority to check the book bag?
She acknowledged when she heard that I was going to do it. She could have gotten up and done it herself if she wanted to.
Okay. So let's talk about, you said you're a part of the crisis management team?
I'm not part of the crisis management plan. I said in the crisis plan.
Are you?
The district holds.
So you're not a part of the crisis management team or any kind of crisis team at the school?
No, I am the reading specialist, and if the principal and administration gives me another duty, then I do that.
Okay. But nobody told you, Dr. Parker or otherwise, that you did not have the authority to remove JT from the classroom. Is that correct?
No.
When the police arrived and you were holding JT, were there any students in the classroom?
No.
Okay. At what point did the students leave the classroom?
When I was walking in, they were coming out.
So by the time that you took a hold of JT and sat down with him, there were no students in the classroom. Can I have a moment?
Okay.
Yeah, they back from lunch. Wait a minute. I'm gonna pull us over so we can get in there and hear all these objections. Thank you so much, Goddess. Yeah, we will. But her testimony is just so like, and it is more of it. If we have a break, then I'll go back to it. But I just think that, you know, it's a tough position. Like teachers, administrators, anybody that works in the school district, they got a real hard job. Like there is so many borderlines because they're not your kid, right? You know, as a teacher, they're not your kid. But in the same token, so you got to be respectful. And I get that and I understand that. I just hate that, you know, everybody trying to act like it's like, you know, one person's dealings. Like everybody is suing. I mean, she already then lost and she owes a civil judgment right now to the victim, Abby, in the amount of $10 million. Then yesterday we had a grandma that was coming to pick up her grandkids that's also suing Dr. Parker. We got everybody suing Dr. Parker. I think that everybody's suing Dr. Parker. Shoot. When I think they need to be suing them all. They can't sue the school, so they suing Dr. Parker. So, you know, that's my whole gripe about all of this stuff when we going through this, because it's like, man, look, I think all of y'all need to be sued. Like, this is crazy. And the crazy part about it, Goddess, is that the main chief was in her office and nobody came and knocked on the principal's door and said, hey, we done went to Dr. Parker 15 times and Dr. Parker has not got out of her chair and did anything about this. Will you please help us? This boy possibly has a pew and I am scared for my life. I would have went home. Like, I'm so crazy about my shit and my livelihood. Let me tell y'all what Sweet Pea would have did. If they wasn't doing nothing, I would have been like, I'm about to go home. Somebody about to move or do something, or I'm out of here. Somebody call the police or something. Like, I'm not working up under these conditions. That's the first thing. And I'm not running here, there, and everywhere. Like, somebody better get up and do something. If the principal was there and Dr. Parker wasn't doing what you needed her to do, then you should have been going to somebody else. See, that's why I keep trying to tell y'all. She didn't really think that he really had a pew. Like, it's just no way. And I'm okay with that if you didn't think it. But don't be trying to act like, oh, you just knew it was one and you just kept telling Dr. Parker and Dr. Parker knew it was one in his bag and she said, oh, just wait a minute. Don't worry about it. I'm going to drink my coffee and I'm going to hang out here and let's just wait and see if he going to pew to school. Like, she was not doing that. Yeah, I would have left my job. Shit, I'm out. Like, if y'all ain't going to do nothing, that's on y'all. Deuces, write me up later. Like, what are we doing here? But all I want her to do is keep it a buck and say, look, none of us knew that he really had a weapon, because if I would have knew, I would have separated him. I would have got him away from the classroom. When he was outside, I would have separated. He wouldn't have made it back to the classroom. Guys, they're saying that on this report that we got, which is the closest timeline from Pretty Brown, it happened at 2 p.m. This stuff started from the time that he kind of walked into school. They could see his demeanor and all these questionable things, but nobody did anything. Nobody put him in a room, detention. I don't know. But, oh, yeah. This is what we doing. And all I wanted to say is everybody just own their stuff. Like, don't be sending her. Why are we sending her up the river? And I guess we send her up the river because she the principal. But I mean, gosh. I mean, I just want people just to say what it was. Like, what your normal what you thought it was. Now she want to, you know, 1 minute it's a weapon, next minute it's a BB gun, next minute it's a water gun, next minute he didn't have a gun, next thing I just knew he had something that he wasn't supposed to have. Like, nobody really related the urgency to Dr. Parker, in my opinion, so far. So yeah, that's right. See, she said she was trying to get back and do her damn test. That's all she got is I was going back to do a test. I ain't got time to be bothered with that. I reported it to her. She didn't do nothing. I had a test to administer. That's all I cared. That's all she cared about. That's all she cared about was doing this doggone test. Oh, I don't care nothing about no damn test. Ugh. All right, well, let's go see what they got live going on. If we have time, we'll go back to her testimony from yesterday. But she is something else. She is a little firecracker, and it go downhill from there, baby, because she's still on there like a firecracker too. Okay, here we go.
We're good.
Okay, Chair, please bring out the jurors.
Please rise to the jury. Jurors in the box.
All right, thank you so much. You all may have to take your seats. Jurors in the box. And jurors, are there any issues to report to the court? Okay, nothing has been said. All right, next witness, Mr. Jenkins.
Commonwealth calls Mark Garcia.
Good afternoon. Come stand in front of Madam Clerk, please. Again.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, sir, take your witness stand, please. Watch your step. You can adjust the microphone and please answer questions the attorneys may have.
Good afternoon, sir.
Good afternoon.
Would you please tell us your name?
Mark Anthony Garcia, Senior.
Right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, you know, like my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
Did MJ attend Richneck Elementary School?
Yes.
Was MJ in attendance at Richneck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Richneck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop them off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Richneck Elementary School sooner than you normally would.
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Richneck, it was kind of like cordoned off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe. And we had to come down Monroe, and when we got to Monroe, we had to stop because there's a lot of cars. So I parked my car in somebody's house, and they said we could park there. And I got out my car, and I parked my car, and I went down the road, and there's a church that's on the right-hand side, and that's where everything was cordoned off by the cops, and that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering with the
middle of the street?
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Richneck to the time you saw your son? This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children. And that came from a delayed reunification. And that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony from the jury.
What's the nexus to why we're here? And I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute. 18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
delayed reunification,
the shooting, Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was.
I gotta pause this. Y'all hear this crap? I am done. Do y'all hear this? This is how they trying to get these 8 counts in, y'all. I know they're not about to have 8 people with their family come up here, their parents talk about how long it took them to reunite with their family, and this was all a ripple effect because Dr. Parker failed to respond, and they had a difficult time between the incident and reuniting with their kids. Because if that's gonna be the case, y'all, then all these pew school shootings should have this kind of these kind of charges going against somebody, because it's real disorganized once something happens, because they trying to figure it out from a lockdown to the time who they should let in to getting the premise secure. So what do you mean this is neglect? But you know, my question is that the judge is supposed to know what these witnesses are bringing in, right? To some degree, right? Or is the prosecution just able to call witnesses as they feel willy-nilly? Because I'm like, he can't be here trying to testify on behalf of his son. Yeah, I'm sure that they had the school on lockdown, you know, until they got the police and stuff there. That had to happen. That's just probably normal protocol. I don't know if they had any pre-hearings, Kim, because it don't sound like it. It sounds like we doing all of this, and just so y'all know, the jury is here. So the jury is here in all the legal battle, all the back and forth, and we got speaking objections. I mean, the jury did already told these people they don't know what to consider and what not to consider. That's why we almost had a mistrial earlier, because the jury don't know what to take and what not to take in. This is crazy. Yeah, I'm sure it was on lockdown. He probably about to talk about it now where he can't get to his kid. I can't imagine them not having a school on lockdown.
The willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
He can describe that out loud. Overall, you may answer the question, sir. You need him to repeat it?
Okay. My son looked confused. He was very scared and very shocked that all of this took place in his school, which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
And objection to relevance.
Okay, I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead, overall.
So my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed in there safely. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just sort of flesh this out.
Yes, sir.
Even regarding the statute, the things the Commonwealth has to prove, this is the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule the defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Just Your Honor, I might agree with Mr. Jenkins that the Commonwealth had to prove some type of serious injury, but that's not what it's charged. It's felony abuse and neglect, but it's not based on any injury. It's based on my conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
Okay. How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
You
you,
have to answer the question
Yeah.
that he asked.
Okay.
Yeah.
So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
okay. And were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions for you.
Good afternoon, Mr. Garcia. I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Richneck, correct?
Correct.
So he was not in Ms. Zwerner's classroom, correct? Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you
No.
picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the police.
Oh, well, I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Sure.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No, I got it. You have
What?
to talk to my attorney.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not going to talk about that on camera. Because it's strange.
Judge, I am going to make a limited objection here in that any civil suits relate to the children. And I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Response?
Well, Your Honor, he just asked a series of questions about the child on camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes.
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
Okay. So you have a financial interest in the outcome of this criminal trial?
Financial. What do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes.
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
Possibly, yes.
Okay. When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay. So 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, Newport News Public Schools. I forgot the name of the downtown director of people, but I know her name is, I know her name, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirects?
Yes, Your Honor.
You've indicated on cross-examination that your son, NJ, was not in Ms. Werner's classroom. What was his homeroom?
His homeroom was Mrs. McAulifre's class.
And did he have occasion to interact with other students from other classes?
They were in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was going to ask you, are you asking me to give the statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
So you can lay a foundation and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation for as to hearsay under the excited utterance.
Yes, sir. Anything on the defense?
Yes, Your Honor. He has, Mr. Commonwealth has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon, presumably hours later, then I don't see how it qualifies as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the clauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at the time, as he was not in the affected classrooms, and there's been no evidence other than that being a student at school since it happened, as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the eviction.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, you're asking to do so out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire to the jury room and we'll bring you out. Thank you.
Please rise to the jury.
Okay, parties may have a seat. If the witness is still under oath, we're going to have some additional questions for you. But one more will work to the door. You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of their classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Okay.
Say that you're saying in or and the
In the danger zone, because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you what did the child say? I mean the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay.
I'm pausing this right here, y'all. This is stupid. And this is stupid. And I'm telling you why it's stupid. Because how is he able to repeat what his child say? And I get that they don't want to put the kids on the stand. But if the prosecution team want to elicit this type of testimony, I think they need to have the kids on the stand. The dad is putting in words for the kids. Danger zone. This stuff. What are we doing here? Like, this is just like no fair. This is like she can't win. This is crazy. Like, how does this even work? Yeah, motherfucker. Like, how are they doing this? Like, why are we not having a child come in here? And I know they don't want the kids to testify. They could have. I don't know. She has the right to face her accusers. To cross-examination, all this stuff. Like, I don't even understand how this is why he even up here. What is he here for? And she like, well, we will have to do every word that this man is saying. Well, did your son say the danger zone? Well, no, he didn't say the danger zone. Okay, well, tell me exactly what he said. We don't know what his son said unless you're going to go down every word that comes out of this man's mouth and ask him if that directly came from his son. And the reason why they're trying to make it relevant to Dr. Parker, because what they're trying to say is because of the trauma and her not acting, I guess, for whichever 8 kids they didn't picked out of this group, it caused some type of neglect. I don't understand. I don't understand how we doing this. This just seems so unfair. It's just unfair, guys. They finally decided to send a jury out of the room so the jury won't hear this illicit, this testimony. I guess you want to call it a proffer. I don't know why they didn't have any pretrial motions or anything like that. I have no clue. And then it's like, my son said that such and such said to him, this happened. And then he not even, and not nothing against the dad, because the dad is just saying what his son told him. But you know how we remix stuff in our heads. You know how that game goes, where you tell somebody, by the time you get to the end of the thing, it's a whole new statement. So I ain't even mad at him for that, but this is ridiculous. Yeah, well, I think that if it's too traumatic, then we don't need, we shouldn't have that testimony. Like, kids have to go through a lot of stuff, right? They have to go through a lot of stuff. They have to testify. And the crazy part is y'all know what? When it's time for the kid to testify, where them dollars at for the civil trial, he be sitting right there in the chair testifying, talk about how traumatic it was. Because all the dad can really testify to is, oh, I had to take him to these appointments. As far as I'm concerned, I needed to take him to these appointments, blah, blah, this, blah, blah, that, in this criminal trial. But I bet you, with the civil trial, they're going to be right there on the stand, talk about, I felt like this, I felt like that. Then the whole kid show go out of the way. Like, we done seen kids that's been SA, that's been seeing their parents do harm to their other parents. Now, no, we don't like to see kids testify, right? If we can get the testimony in some different type of way, but this just seems really backhanded. He done already set up here and said, look, hey, I got an interest in this. If she's convicted in this, then I might be able to win my civil suit. Remember, I said this when we started this trial, was really, really different, that the civil suit with Abby went through before the criminal trial. Because typically we'll do the criminal trial, and then that gives them like the leeway, because they can go in there and say, okay, now she liable, civilly. That makes that like a walk in the park. And I wonder if it's going to be the same, because, she appealing that $10 million judgment with Abby. So if she gets off on this is important, because she's appealing that. If she gets off with the criminal part, she may have some leeway in order to get out of that lawsuit that she lost. Okay, I'm going to try to be quiet, but y'all know I'm about to lose my stuff over here. I'm like, I can't. I'm up here trying to type, but this is crazy. Hey, Zach, how are you? I'm yamming about this doggone case. They about getting on my nerves. Here we go, guys.
I was going to address his characterization of dangerous on the court.
Judge, I'm not going to seek to admit the statement. We need to bring the jury back in. Thank you, Mr. Garcia.
Yeah, no, you don't just you can keep your seats this time. Not when I gave you a break. It was just a few minutes ago. You can bring them out, but everybody doesn't have to stand. You're all welcome to have a seat once everyone comes in. Thank you very much. And normally they stand. I told them that they just stood. They didn't have to, so it's no disrespect to all. It was You may finish with your questions if you have any more.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Richneck Elementary School?
Yes.
Had you personally ever gone to your son's classroom? And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Cross-examination?
I think we're fine.
Defense has no questions. Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection to it.
He can be released.
Okay, so sir, what that means is you're released from your obligation as a witness. You may stay in the courtroom, you may leave and go about your business, and thank you, sir.
Thank you so much.
And next witness,
Commonwealth will call Susan White.
Susan White.
Susan White.
Thank you.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Your Honor, if I may.
Yes, sir.
I know the court has already ruled on Mrs. White's.
Okay, come on, hold on one second. Come on in the witness stand and watch your step, and yes, you can move the chair and microphone. Yes, Mr.
The court's already ruled on Mrs. White's ability to be able to testify today. I'm renewing my objection to any testimony she will give regarding how it's not relevant to what happened on January 6th regarding my client's conduct in the actual mission that occurred on that day. She can't testify to that because she didn't observe it. So I don't believe that she has anything of relevance to offer the fact finder to be able to decide if my client's conduct is reported on it.
So noted, thank you. You may proceed, Mr. Chairman.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Richneck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
No, I'm sorry. I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked. So it definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Richneck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up. This was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up.
And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching.
Okay.
I was still talking with the students.
Let me pause you for a moment so we can kind of visualize the scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Could you describe how you did that?
I slid the chair I was holding the back of the chair and I slid it back. We had no carpets at that time because of COVID. So it was easy enough to do.
Yeah.
And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple feet further and then I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class, and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the teacher's assistant that I shared with another teacher happened to be in there at the time. She was in the back of the room. So she came up and pulled him off with me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Parker, my assistant, took him out of the room. But then sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay.
Yes.
So when
They
you
each had him, I'm sorry.
when you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand and they were trying to get him to move into the room. And he was yelling, no, I don't want to go back in the classroom. And I looked at them and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point, I was so shaky that Mrs. Carter, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute. You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally to the administrators.
And when you say the administrators, what titles do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Richneck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes.
Could you just point her out, please?
She's right there.
Okay. Will the record reflect that she's indicated dependent?
I was not able to see point it out again, I didn't see your hand. Okay, so noted.
Thank you, Jim. So you've told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day, because I had had some positive moments with him earlier, so I wanted those included too. So typed up the day, and then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, did, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
No,
have
she was making eye contact. She was looking at me. She didn't say anything.
Okay.
Dr. Goodman said, sort of under his breath, prioritize. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did.
Okay.
He returned the very next day. He walked in with his breakfast.
Okay.
And I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it and come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office, and I knew at that time that my assistant had to stay in a first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm gonna have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
You have a moment?
Yes, sir. I'm sorry.
Are you all right?
Yeah, I'm okay. I thought he was asking me. I'm
Oh, no,
sorry.
just take a moment to confirm.
Hello, Ms. White. You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct?
Mm-hmm.
Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right, and I heard, but,
No, you don't have to tell me what you heard.
okay,
So when you told her that action was taken and justice was, JT was removed from your classroom.
he went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
And read direct.
Yes, Your Honor. Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may.
May I see the exhibit?
You may.
Sure. May I approach the witness, Your Honor?
You may.
What is it that I paid?
You handed me the detailed description that I attached to the incident referral form. And
Oh, okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes,
Has anything been redacted from it?
well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category? I don't know, I sort of words. Is it names?
Names.
Hold on one second, ma'am. What? Yes, sir.
Before she even answers that, objection, that document is hearsay, it's an out-of-court statement, it's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She's testified that she produced this incident report, but as far as the contents of that incident report, I'm objecting to it as hearsay.
The objection is premature. I haven't offered any evidence yet.
Agreed, premature, not yet right. You may proceed.
The redactions that appear, are they redactions that you did?
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take a time to read it.
Yeah. I was gonna say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the
Okay.
attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as a prior consistent statement because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-exam.
Your Honor, there was no such insinuation that it didn't exist. So that's number one. It's still hearsay. It's duplicative of her testimony and all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, Your Honor. It goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she recalled happened, I think it was a year before?
Yes.
So, okay, I'm talking to the attorney.
I'm sorry.
She testified to what she believed happened to a year before. Why are we allowing in her written statement, her redacted written statements about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach. And so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination, the witness has been challenged as to having a memory or forgetting something. I could find the rule.
And so, and again, I understand that's where the impeachment comes in, but that's the missing link for me. So, saying it does not come in, and you may approach to retrieve the document.
Thank you, Judge. So I thank you. I don't have any further questions for you.
Anything further? Okay, and the status for this witness? May she be excused?
I'd ask that she be released unless, I'd ask she be released.
Okay, no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, so watch your step in. Thank you very much. Next witness.
Commonwealth calls for Alonzo Rawls.
Raise your hand, sir. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Please take a witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon. Would you please tell us your name?
Alonzo Rawls.
Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor.
Where?
At Newport School at Richneck Elementary.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richneck?
It probably would have been, between that time, it would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Richneck, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes, in his second year at Richneck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help us with adjustment to the school and be more productive. So I believe the administration came with a plan up, and they administration need to help them out with that plan.
Tell us how, if you could, just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some things like reading assignments. She was a reading specialist at that time. And then when that point, after her time was up, I would come back, retrieve him, and I would take him to the classroom. And I would be with him in the classroom.
Okay. And did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
My recollection, I don't recall. I just remember this is what they were requesting.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, on his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that? Can you tell us?
Student support team. It was basically a process or a program to put in place to help to assist them in trying to once again be more productive in the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and it was called the SPED system.
Okay. And who all was involved in the SST process for JT?
I was currently at the time on the Newport Public Schools and policies. Counselors were one of the main people that ran the SST process. Administration would be involved when they were available and things of that nature, but it was more so put on responsibility of the counselors.
Okay.
Coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AD, myself, or another counselor, a parent, and if they had any advocates that would willing to be part of the meeting. That's how kind of group of people would be.
Were parents and guardians of children invited to attend those as well?
Yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, assistant.
Thank you. And as of JT's SST, who was the principal at the time?
During the time, the principal.
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was the principal during the SST process in that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because.
Hold on just a moment.
Okay, what happened? I heard something. Object leading. Okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
As a
Okay, same objection? Yes. Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment, And did you decide is a question he can answer yes or no. He did decide it or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to just continue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that, or do you want me to just?
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
It wasn't really a decision of sorts. It was a request. As a school counselor at that time, I had many students that I had to serve, and I felt like it took away my opportunity to service a lot of the other students within the building. So I had a request that if I could be relieved of that duty, so I could also service the other students. Besides, I could still assist. I heard it needed to be done with JT, but I also wanted to be able to service the other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew the relationship we had, me being his one-to-one, that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
At times, yes.
Okay. I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realize something might be up with JT?
Objection, leading, assumes facts not in evidence.
I'll rephrase. On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later. That was in that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something.
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it in an earlier time where they still holding on to it as it was stated.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went is I went to Dr. Parker to address without the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else. And I requested her if I could take some action.
Okay. And what action did you ask Dr. Parker to take?
I asked her if I could take action of trying to search or to check the person of JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, his parent or parental guides would be coming to get him so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person that's like concerned, I shared my concern with is when I went back to speak to Mrs. Zwerner after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
You know, my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day?
Yes.
Okay. Thank you. I don't have anything further.
Good afternoon, Mr. Ross. How are you? Good. Hopefully I won't keep it too long. So on January 6th of 2023, you were the school counselor at Richneck, is that correct? Okay. And so at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
Okay. But at some point you began one-on-one contact with JT, is that correct? Okay, and how were your initial interactions with JT? Were they positive, or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself, I would say.
Okay, and so over a period of time, his behaviors began to get better. Is that correct?
I would say yes.
Okay, and you were part of the SST team. Is that correct? Okay, and you function as the counselor as a part of that team?
Yes, counselor.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. And would you say that you had more contact or less contact with JT than Mrs. Kovac, the reading specialist?
I would say we probably had
about the same amount of time? Okay. And at some point, you indicated that you requested less one-on-one time with JT.
Yes.
But it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my standpoint, I wanted you to be able to be more accessible to students.
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it, so that the reporter can get your words in. Thank you. So if you repeat your answer.
Oh. Can you repeat the question?
So you got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students and more people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead, and I know we're hearing that mechanical squeaking now, we think it's a chair, so just, well, you know where it came
No,
from?
it wasn't a chair. It was a voice or something like that.
Well, do you know where it's coming from, or feedback?
It seemed to be from my right.
Oh, okay, so again, there are other courtrooms and other lockups, we can't do anything about this noises, I'm sorry, just ignore them. These things on the wall, these are sound panels. So we have as many as we can have, as you see, to absorb all the sound. So we'll just have to do our best to move forward.
Thank you, ma'am.
Okay,
I
repeat
understand.
your question, please.
So my next question is, do you, when you began to have less contact with JT based on your request, did you think that was a good move for JT? Do you think that may have been detrimental to his progress?
I can't even really answer that.
Okay. But based on your position, you thought as far as resources, you needed to have contact with more students. Is that correct?
Yes.
Okay. Maybe it's that's what it is. That's what it is. So I'm the source of the distraction. So after you decided to have less time with JT, did you notice any kind of degrade or in his behavior?
Not necessarily, because another plan was put in place to kind of I won't say replace me, but to try to subside.
Describe that go around or that next plan.
Well, the next plan, from my understanding, was that authoritative figure within this family would be able to come in to assist and support him in his times process.
Okay, and so you actually observed that next phase of the plan with JT. Okay, and did that next phase seem to cause improvement with JT's behavior?
As far as I know, once I was alleviated from that, I wasn't so hands-on, but I would say it seemed like he was kind of improving, yes.
Okay, so were there less calls from a teacher or from an administrator for you to respond to JT due to bad behavior?
On my understanding, yes. It was less calls to me, yes.
Okay, all right. Now let's talk about January 6th. Did you have contact with JT on January 6th of 2023?
Later than after, yes.
Okay.
Not like direct contact. I observed him.
Okay. You said not direct contact, but you actually observed him. What? So as a result of hearing information, you decided to go and place your eyes on him. Is that correct?
Yes.
Okay. And when you placed your eyes on him, was he in the classroom or was that on the playground? Where was he at? In the hallway?
I placed my eyes on him, he was in the classroom.
Okay. And when you placed your eyes on him, did his behavior that you observed, did it cause you concern?
No.
Okay. Did he seem like it was JT, his normal behavior? Is that
Actually, it seemed abnormal behavior. He was way calmer than he normally was.
Oh, okay. So he appeared calm. How long did you observe him?
It was a few minutes. It was long.
Okay. And during that few minutes, JT was doing okay. Is that correct?
Yeah.
Okay. And is it safe to say that you may have had some concerns for JT's safety or anybody else's safety, and that's why you wanted to put your eyes on him? Is that correct?
Well, not at that time. At that time, like I said, it was abnormal for the behavior to be that calm in that setting.
Okay.
But I didn't have any concerns of him.
Okay. So you put eyes on him and you were satisfied that JT was doing well that day. Is that correct?
Yeah.
Did you have contact with him directly or indirectly after that?
No, I did not.
Okay. So you did not observe any behavior of JT on that day that made you believe that JT presented a threat of danger or harm to any of the students. Is that correct?
That's correct.
Okay. And I believe through the questioning, it seemed like there may have been an indication that there was some additional feedback that you received. Is that correct?
Yes.
Okay. Did that cause you to need to put your eyes on JT again?
The initial feedback that I received had me concerned about what was being said, and that's when I wanted to address it with Dr. Parker and things of that nature. The only other time that I saw JT, and I don't even recall really seeing him, particularly when I went back in that classroom. I don't remember actually seeing him at that time.
Okay. Okay. And do you remember the timing of that when you went back into the classroom?
Once again, it had to be between the hours of 12:45 to 1 something.
Okay.
But I don't recall the exact time.
At any time did you feel like that you needed to step in and pull JT out of the classroom?
Only time that I felt after hearing the feedback that I would receive, and then once again I was told to hold off on that.
Okay. Did you agree with that decision?
At the time, I felt like it was the decision that was made, and whether I agree with it or not, I was just there to be support. When I came back to the classroom, I spoke to Ms. Zwerner, I told her what was said, and I just told her that I would be there if she needed me.
Okay. When you left Ms. Zwerner, did you feel like you were leaving her in extreme danger, or the students in extreme danger?
No.
Okay. When you walked away from that class, you were at peace with JT's behavior, what was going on in the classroom. Is that correct?
Yeah.
Okay. Now, so when the actual incident occurred, did you immediately think that, oh no, JT has shot somebody?
No. When they went into lockdown, I thought it was a drill initially.
So you were shocked that the incident actually occurred. Is that correct?
That's correct.
Even with the earlier feedback that you received. Is that correct?
That's correct.
Okay. You did not think that you needed to take any action to prior to the incident to separate JT from the classroom. Is that correct?
That's correct.
Separate his classmates from him. Is that correct?
That's correct.
You didn't feel like you needed to call the police? Okay. All right. If you believe that there was a gun, do you understand that it was your responsibility to separate JT from the classroom?
Yeah, I mean, that would be my responsibility.
Okay.
It was.
Okay. And it would also have been your responsibility to contact authorities. Is that correct?
Correct.
Okay. You had been involved in previous incidents when JT was removed from the classroom. Isn't that correct?
Yes.
Okay. Just a couple of days before that. Okay. You were involved in that incident.
Yes.
Okay. Okay. You removed him from the classroom?
Yes.
The incident wasn't something that caused danger of harm to his classmates. It's a cell phone was broken. Is that correct? And that resulted in him being taken to the office. Is that correct?
Yeah, it's like, it just
Okay.
stopped up a little bit, but nothing major.
Okay. So as a staff member, even on that day, you understood it was your responsibility, if you thought that there was a threat to the students, to remove the threat or the students from that danger. Is that correct?
Objection asked and answered.
Yeah, that's fine. Ronna, can I have a moment?
Yes, you may.
No, that's all good.
Thank you. Any brief directives?
Briefly, yes, Judge.
Yes, sir.
Just so that I understand the timeline of events, you testified on cross that you went and put your eyes on JT. Do you know if that was before or after you spoke with the student and it caused you to go to the assistant principal?
No,
Before, okay. Do you know roughly how long before you spoke with that student? Okay. Would it have been more than 2 hours?
it was earlier that day.
Okay. And what were the initials of the student that you spoke to?
I don't remember the first initial R.
Okay, thank you. I don't have any further questions, Judge.
Anything further from the defense for this witness?
Just a moment, Your Honor.
Hello, Mr. Ross. You just mentioned speaking with a student with the first initial of R. Did you ever tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you did? Okay. Would you be surprised if you did not do that?
I wouldn't be surprised.
Okay. No further questions.
Any further from the Commonwealth?
Judge, based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take this is a good time for stretch break and after lunch restroom break. So it's 3:25. Let's come back at 3:35. Sir, so you're still under oath, but you can step down and retire to the witness room, and we'll bring you back out, and we'll have the jurors go back to the jury room. Thank you all. 10-minute recess.
Please rise for the jury.
Oh, goddess, that was too so funny. She said, "Get the off the stand." Oh, that tickled me. Oh man, I tell you, like, is he almost 10 now? Oh yeah, maybe he wait. This happened in 23. He was 6. He was choking teachers when he was 5. Like, they sound like he around a whole bunch of adults that don't know what they doing. That's what it sounds like. So 6, yeah, he about 9 or 10. Would you say she'll remind them not speak about the case? That's why they going back there talking, because they don't know what's going on. They don't know what it's doing, what they talk about. I mean, everybody got to take a break before they cross-examine. They ask somebody a question. Like, it's insane. Thank goodness we got a little TiVo time, so we don't have to really take that whole break with them. But this case is just, You say he must be pretty tall, Phil. I wouldn't care how tall he is. I would, but man, look, he could have not been choking me and it go down like that. It just not gonna happen. I don't know. Shout out to these teachers, because they just let him run over them. JT ran this school, baby. JT, if you out there, baby, Sweet Pea say you ran that school, and I guess you can be the boss. I don't get it. He couldn't boss me around. It's like he bossed the whole school around. Like, JT might come in the courtroom, and I guess the jurors are supposed to shake in their boots. Like, JT got it, baby. He running them all. I mean, he got the men scared, the women scared, the teachers. Can't nobody call nobody. Can't nobody call nobody for help because JT got it. It's just no way I'm gonna be scared of no 6-year-old, and there's no way that no 5-year-old, almost 6-year-old, whatever they want to call him, is gonna be behind my neck, and I can't get him off. Yeah, he objects to all this stuff. He didn't get charged because he's 6 years old. Like, that means don't nobody got no control over him. nobody has no control. Nobody's really trying to figure out what's needed. Sometimes kids have to go into like mental health facilities to try to figure it out. You have to detach from them. Maybe the home environment. I don't know, but what I do know is that JT got these people running scared, baby, and it is really frightening to have these many adults around and nobody is saying, nobody thinking nothing. Ain't nobody got. I bet you he had an IEP, a 504 plan. He had all those things in place, and yeah, I don't know. But I'm gonna take us back in here so we can see. But this is just such a mess. JT, I can't believe they let no little 6-year-old run them like this. Yeah, so that's why. Yeah, I believe Amy. No, Amy says, sure. He was gonna beat me up. Yeah, he punched my glasses. He got the cussing and he got to being cocky and he knocked my glasses off. I guess he might have punched her in the face. Told her to get off of him. Oh, Amy. She the prime person that to be sitting over there at the defense table. I just think they need to have both of them at the defense table. I think they need to sue them both. Like if they knew what I knew, they should just be suing them both. Then that way they can probably get some money. Cause I mean, yeah. Here we go. Let's see what we got. And I wish he would tell him, put your mouth on the mic. Shit, grown man sitting up there whispering. Maybe JT in the back of the courtroom, he's scared. Shoot, JT got them all scared out of their boots.
All right, so if you resume the witnessing and the sheriff, we can bring the jurors back up. Yes, ma'am. Yes, you need to come and connect audio. Oh, please come on up. Okay. Thank you.
I got this one.
Okay, we got that one. What about the other one? He said this one. Okay.
Yeah, I turned most of them.
Okay, thank you.
Please rise for the jury. Jurors in the court.
Okay, go on and have a seat. Thank you. You may resume your redirect. I'm sure I'm here. Redirect.
This is redirect. Okay. Yes, be quick. Mr. Rawls, thank you. I believe you indicated to the defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that? Sure. Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay, may I approach, Judge?
Yes, and you responded yes, correct? Yes. Okay, and he nodded his head. I just wanted to make sure it was recorded. Yes, you may approach.
I'm just handing you this document to take a look and read there. We're at the pink post-it note, and after you're done reading, look up and I'll ask you a question. Hold on, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
To an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
I'll go
Okay,
get
so
it.
what's your
May I
objection?
approach?
Okay, you just like him to.
I want this done properly. Yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on, now let's refresh, if he has an independent recollection.
Well, he said to an extent, so
Already
we'll
did.
flush it out, and we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
When I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT and nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct? Okay. And at that point, you did not believe there was any credible threat, correct?
Objection asked and answered on recross.
No, I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls, may he be excused of this, he needs to remain.
I'd ask, oh, I'm sorry.
No, I'll follow you.
I'd ask that he be released.
Oh, no, we're going to ask that he be done.
So we're going to ask that he be constructed. I agree to that. We'll ask that he be constructively sequestered, remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, come on, Captain.
Absolutely, I do be happy to facilitate that happening.
Okay, so Mr. Rawls, what that means is you are still a witness. You still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave and go about your daily business. You will either get a phone call, one, to come back to the courtroom, or two, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir? All right, thank you, you may step down. Next witness.
Megan DeLeon.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Thank you, ma'am. You walk around, please, take the witness stand, watch your step. The chair and microphone are adjustable. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan DeLeon.
Ms. DeLeon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Richneck Elementary School.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me, her dad. It was later on in the evening when she kind of showed different behaviors.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of. But the doorbell rang just for pizza, and she just got very scared, jumped from her seats. The sound of a doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of the door. I know just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
Mayor, I'm going to object to her statement. Sounded like a ladder when the gun went off. Sounds like she's testifying as statements that she may have stated. If that's what she has done, I'm objecting to it.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understand why anyone hurt her.
And who was her teacher, if you know?
This morning.
Okay. So Ms. Zwerner, was Ms. Zwerner's classroom her homeroom?
Yes.
Okay. As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questioning?
Only to elicit any additional different things that she noticed in her daughter. That's it.
I'll allow it. You may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling because it's the time they said to start doing. To give her some time and re-engage with the counselor, and they said that she has depression, anxiety, and one other thing where she holds an alert.
All right. Thank you. I don't have any more questions for you, but thank you.
Good afternoon, Ms. DeLeon. You were never inside of Richneck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. So, and you did not encounter your daughter in the building, correct?
Right out front. No, they brought out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes.
Okay.
What do you mean by that?
There's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my opinions of the case.
Well,
It's more of a
I'm
personal-
going to object, Judge, and ask that we not talk about a child's civil matter on TV, that we have not continue the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the questioning party has a right to cross-examine about interest in the case. And if you just ask who the named parties, not what your opinion is. And I think you said I prefer not to share my opinion on it. So non-responsive as well. Repeat your question, Mr. T.
thank you, Your Honor. In that civil lawsuit, you have named Dr. Parker as a defendant, correct?
Yes, please.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Yes, but the loss, I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
No, Your Honor.
And the status of this witness?
We'll ask that she be released, and we're also calling Nicholas DeLeon.
Any objection from defense to this witness being released?
No, Your Honor.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you. And the next witness's name again, I'm sorry.
Nicholas DeLeon.
Okay, Mr. De Leon, please.
Your Honor, I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that he will be able to testify to anything other than it is.
I don't know who they are, so, okay, tell me why it's cumulative.
Husband and wife.
Mother and father of the child.
Okay, it's just one witness, I'll allow, I mean, are you bringing out 5 relatives for the same time?
Absolutely not, Your Honor.
Okay,
Absolutely
you
not.
come out
This is it.
overruled. Mr. De Leon, please.
swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
So please take the witness stand, watch your step, chair and microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas De Leon.
Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richneck Elementary.
Okay. And are as of January 3rd, 2023, were you? Let me ask the question like this. Who is SD's mom?
Megan De Leon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time.
Okay.
Months.
Okay. Did you and her mom seek any sort of treatment for her?
Yes, counseling and spiritual counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
All right. And just to confirm, whose class was SD in?
Wonders.
And was that at Richneck Elementary?
It was.
All right. Thank you. I don't have any other questions for you. Please answer any from defense counsel.
Good afternoon, Mr. De Leon. All right, you mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Zwerner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there.
Okay.
I can't verify that. But
So you can't verify that. I'm not asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know what the status of your relationship, but Megan De Leon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
Correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. It's on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case.
Just answer my
That's a
question.
separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. You said no.
No, it has not been asked and answered, Your Honor. I asked a different question.
Well, it's a different question, and I think you already answered it. Are you asking this answer to be struck?
Yes, it's irrelevant and duplicate.
Overruled, and your answer was no, sir. If I heard you correctly.
Correct.
Thank you.
No further.
Questions?
No further questions, Your Honor.
Any redirect
No, Your Honor.
and status of this witness?
I would ask that he be released.
Any objection? No objection. Okay, thank you, sir. You excuse me, duties as a witness, you may stay in the courtroom or leave as you see fit. Next witness.
Commonwealth will call Tanisha Richardson.
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes.
And cross your step and the chair and microphone are adjusted.
Good afternoon. Would you please tell us your name?
Good afternoon, my name is Tanisa Richardson.
Ms. Richardson, do you have a child?
I do.
And in January of 2023, was your child in school?
Yes.
What are your child's initials?
KS.
All right, and just as a reminder, we're only using initials, not names today. Where was your KS in school?
He was in his classroom. He was in first grade in Ms. Zwerner's class at Richneck Elementary.
All right. And did there come a time earlier than normal on January 6, 2023, when you had to go to the school, Richneck, to pick up KS?
Yes, I received notice that there was a community post on social media that there was a heavy police presence at the school.
Okay, let me stop you there. You're okay. Just let me ask you questions and I'll walk you through it, okay? So after you saw what you saw online, did you go to the school?
I did.
Were you eventually reunited with KS?
Yes.
Could you describe, without telling us anything that he said, could you describe his demeanor, how he appeared to you when you first saw him?
He was very tired. He was cold. And he was ready to get home. He was just really exhausted from the day.
Yeah. Did you notice any changes in his behavior after January 6th of 2023 as opposed to before?
Yes.
I want you to just describe what you were able to notice as his parent that changed after January 6th, 2023.
Oh, sorry.
It's okay, I understand.
And the news is directed to Bill Fleetback, so it's not going to go out to the press. I just wanted to assure you, we will catch it.
Thank you, I'm sorry. Bedwetting, stomach aches, headaches, school avoidance, just a general anxiousness, just extreme fear, as well as hypervigilance.
When you say school avoidance, can you kind of describe to me what that means?
He was literally afraid to return to school.
How long was he afraid to go to school?
I would say until at least the end of the school year of that year.
Did you seek any type of treatment for KS?
I did.
Okay. What did you seek?
He actually had a psychologist initially, and then he also attended CBT therapy with a counselor weekly.
And how long did that go on, and is it still going on?
I would say it lasted about 1.5 years to 2 years, and we stopped it since then because his therapist went to a new practice.
Okay. Do you think that it has helped KS?
It has helped.
Good. Thank you. I don't have anything further for you. Thanks.
Good afternoon, Ms. Richardson.
Good afternoon.
You currently have a civil lawsuit pending in this courthouse, correct? Regarding the incidents of January 6, 2023?
Yes.
Okay. And you've also, in that lawsuit, you've named Dr. Parker as a defendant, correct?
Unfortunately, I'm not. I don't feel comfortable discussing the details of that in this room.
Your Honor, I'm just going to renew my prior objection. I understand the court's rule on the issue.
So the court will overrule the objection. It's appropriate to be discussed. So if you could please answer the question. Repeat your question, Mr. T.
Thank you, Your Honor. In the lawsuit that you currently have filed in Newport News Circuit Court, you have named Dr. Ebony Parker as a defendant, correct?
Correct.
And in that lawsuit, you are suing Dr. Parker and the other defendants for money, correct?
Yes.
Okay. And you and several other parents share the same attorney, correct?
That's correct.
And you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit, don't you?
No.
Okay. Have you made any other demands of Dr. Parker or the other defendants?
No.
Okay. Do you know when that lawsuit is scheduled to go to trial?
No.
Okay. When was that lawsuit filed?
I believe it was February of 2023.
February 2023?
I don't know.
Okay. Okay. No further questions, Your Honor.
You may proceed.
Just a couple of more questions for you. As a result of the incident on January 6, 2023, and all of the things that your son has done, have you spent money?
Yes.
I'm going to object to go beyond cross-examination.
I think that's right on point with the cross-examination. He asked if she was seeking money in a lawsuit, and I think it's very fair for me to ask if she also spent money as a result of the incident.
I'll allow it. You may proceed.
Did you spend money as a result of what happened to your son?
Yes.
All right, thank you. I don't have anything further.
Anything further for this witness?
No, Your Honor, I asked that she be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as a witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
Please take the witness stand, watch your step. Answer questions of counsel. Thank you.
Good afternoon, sir. Would you
Good
please
afternoon.
tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to just a quick reminder that during this trial, we're not speaking the names of any children at all and only using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school? Did Gigi attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade
And where did he attend school?
at Richneck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abby Zwerner.
All right. Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Richneck?
Yes, I did.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it. Okay. So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you.
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
Okay. And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January 6th?
That was new after that. Okay. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. Mm-hmm. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat.
Okay. And has he, at any time between then and now, has he sought any treatment beyond that?
Not since then. No.
Okay. And how long did any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings, and the whole big wedding thing happens. Yeah, it's pretty rough.
Did your family incur any expenses as a result of this?
As far as with the
for Gigi, as a result of this, did you have some expenses?
No, with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Thanks.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Richneck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact,
Mm-hmm.
of course. Did the school contact you at the time of the shooting?
No. I had a friend of mine, a coworker, contacted me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Zwerner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
Your Honor, I'd like to note my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
Your Honor, I said he'd be released, please.
Any objection from the sentence?
No objection.
Okay, thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
And the Commonwealth will call Sarah Gonzalez.
Your Honor, again, we're going to object. This is a duplicative witness that adds nothing to the case. This is the last other parent of the child, the second parent of the child.
So noted, overruled. You can bring out the witness. Thank you. And this is the last witness?
This is the last witness, Your Honor.
I'm not gonna, I'm just trying to line up.
I understand. I understand. I will take a moment to double check that this is
Understood.
that we're
Understood.
ended, but yes.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Thank you, ma'am. Please take the witness stand, watch your step, chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes,
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him.
When you first see him on January 6th, 2023.
At our home.
Okay. When you first see him at your home, is it still on January 6th?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me, without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
When my husband came home with him in the car and he came out, he was like he had seen a ghost, kind of. He was white and his eyes were very big, and he was just kind of, I've never seen that look before, but he was kind of like he was in shock.
Okay. Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and it just is, to this day, he still sleeps with his older brother, and he just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and just becoming angry, things like that.
Yeah. And for how long did those things last?
For a long time. It's improved. I would say, but it still occurs. It was very frequent after that for quite some time.
Are there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward, and, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety, and,
I agree, Judge. We won't go down that road.
Okay, so we won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from defense counsel.
Good afternoon, Ms. Gonzalez. You have filed a civil lawsuit in this courthouse as well, regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that, as it's relevant to my son.
Objection noted, and you do need to answer, please. Repeat the questions.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by in the civil suit. It's not in any way relevant.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
I'm going to sustain the objection. Who their attorneys are, it is not relevant. But, you know, that there's a lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right? What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right? I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
That's all for this witness, Judge, and I would ask that she be released.
Any objection? Okay, ma'am, so you are excused from being a witness. Thank you for your testimony. That means you can stay in the court or you may leave. And watch your step as you step in.
Judge, may I have just less than 1 minute?
Yes, sir.
To confer.
You can sit down. Thank you, ma'am. And the sheriff will direct you.
Your Honor, the Commonwealth rests.
Your Honor, we will have motions to strike, but I do want to take time with my co-counsel and the defendant to make sure that we have every base fully covered. So I'm going to ask the court to consider going on recess for the remainder of the day, and then we'll come back first thing tomorrow and make our motions and present any evidence on behalf of the defense.
In terms of proceeding in that chronological fashion, your position.
I'll submit to the court.
Okay. All right, so to the jury, we take up the motion to strike outside the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is council prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine for you.
Understood.
Your Honor, we can be prepared for 9 o'clock tomorrow morning.
Say that start at 9?
Yes, 4 motions to strike. Yes.
4 motions, and ask the jurors to report at 10.
Yes, ma'am.
Okay. All right, so thank you again for day 3. You have the same cautionary instruction. Please do not discuss the case, research the case, allow others to discuss it and or share their discussions, their thoughts, and opinions with you. I know that's hard. I know this is a high-profile case, but that is important to the integrity of the process. And please report at 10 a.m. Are there any issues, anything I can assist you all with? Okay, and last, please, I will not be able to court to provide lunch tomorrow. My assistant's off. And she's the one who, while we're here, actually goes to pick it up. So bring your lunch or be prepared to go out to get food tomorrow. All right, thank you very much.
Please rise to the jury. Make sure you move your elbows.
Your Honor. No, Your Honor.
All right, we'll be in recess. Thank you. See you all at 9 a.m.
Thank you. Thank you.
All right, and if they'll come, oh, I saw him use that.
I don't see how they could find her guilty. I just don't see it. Not with all this confusion. I think they got to do a hung jury. Like neither side. It seemed like everybody that's coming in here testifying, it's either deflection when you talk about Amy. We know that Abby got her money, right? So Abby, she's like the only person. I know she was expected to testify. I just really don't even think she has to testify. Me personally. Then you had these last 7 witnesses that got up there talking about, hey, I guess that goes to the neglect part of it. They trying to say that it was secondhand neglect. I think this is crazy. I just don't. I can't see how the jury will do it. But once it gets back there to a jury, we don't ever know what the jury gonna do. But I've never seen a jury ask questions like they asked. That was weird. Just so you guys, if y'all not aware, that's weird. Those questions, coming in like that. But I guess we'll find out more I guess tomorrow. What's tomorrow? Thursday? Okay, well, maybe the jury will still have it by Friday. This case is such a mess. Okay, so I know that we have our day 3 for our Tennessee case. Everybody make sure they have on a I don't know, make sure you had your lunch or your dinner, whatever you need to have, because ain't no telling what type of disgustingness might be shown over here in this trial. That's what I can tell you. So you make sure that you have all, if you're coming over there with us to Tennessee. We are covering a case over there where a young man, Jordan Allen, he was 16 at the time. He is now, I want to say he's 18 now. He is accused of unaliving his grandmother, who was 59 years old, and his brother, who was 7 years old, utilizing a hammer. Conflicts of interest because, he say he only confessed because granddad coerced him to, convinced him, made him confess. Now, I don't know. I don't know if he did it or not. So we got a lot of things going on. Yeah, and with this one, yeah, definitely a hot mess in all aspects and retrospects. Like, I don't even know what to say about this one. You heard Billy did it. I know, I heard Billy did it, and I heard Jordan did it. I don't know who did what, when, where, and why, but yeah. Yeah, I did that 911 call so people could kind of see what they hear on it. But yeah, I don't know. Maybe because everything was just going on at that point in time that they just, I don't know. So I know we're going to go over there and start watching our day 3. 1 and 2 is on our channel if you need to watch it. There's some different clippings. We'll be back in this trial for day 3 tomorrow. And it's so funny because y'all know, like on the major channels, like this is the only case that's being like covered. And it's almost like the most, I don't want to say, I guess I could say like weird case, I guess, like the way it's structured and things that are going on. But who knows? Yeah, we're going to actually do something tomorrow night for that, Goddess. We got to do our round 3 before we go into trial Friday. I got some ideas of what the defense is going to be doing for Alicia Andrews. I think that's going to be definitely her sentencing. Yes, her sentencing, but I can tell you what the I think I know what the defense, what their plan is. Because they did some documents that we'll go over tomorrow night. I'm gonna actually do that tomorrow night. So we'll be ready for Friday morning. That should be exciting. So I did set up our new room for our Tennessee trial. We are about to go over here to see Mr. Jordan Allen. Day 3. It should automatically reroute you over there. If it does not, I did put the link in the chat room. You can click on that link and it'll take you right over there for you to have a seat. I want to say shout out to the mods, shout out to the chat. I want to say thank you so very much. You could have been anywhere because everybody who is somebody is streaming this trial. And I do mean everybody that's somebody. So you could have been anywhere, but you decided to stick it out and hang with me. And I truly appreciate it. Shout out to all you guys. Shout out to all our new members, all our new chatters and subs. And I will see you over here in Tennessee. Ooh.